Zahida, can I just check, are we covered?
Good morning, Chair. We can continue. Member van der Westhuizen is here while we wait for the other members to arrive. Well, we could start. Yeah, it's about 8 o'clock. We can start.
Okay, thank you. All right, with that, I would firstly like to welcome the members who are currently online, as well as the officials from the Department of Trade and Industry, as represented by DDG Evelyn Masocha. You're very welcome. And also, I'd like to welcome members of the public who are here today. I want to confirm, Zahida, we haven't received any apologies so far.
No apologies from my side, Chairperson.
Okay, thank you very much. All right, then just a few house rules before we get started. So as today is a virtual sitting, we will be having an opportunity, or we will have the opportunity rather, to provide feedback. But in the meantime, while the department is providing their presentation or their deliberation, please could you keep yourself muted, and could you kindly turn your video off? To indicate that you have a question or a comment, you can use the raise hand function. And when you're called on to speak, then you can unmute yourself and you can also turn on your video. With that, I'd like to give members online an opportunity to introduce themselves.
Good morning, Chairperson. Andrikus van der Westhuizen, a member of this committee.
Thank you. I see no other members for the time being, so I'll hand over to the department.
Good morning, Chair. Good morning, Honorable Member, and good morning to my colleagues who are on the platform. I'm with Mr. Klas Magaba and Mr. Saroj Naidu, and the other colleagues. I'm sorry if I haven't seen your name so far, and to the members of the public. Chair, we are here to give feedback on the public submissions that the department has received from the Western Cape Parliament. We have prepared a matrix, Chair. Usually what we would do is to prepare a presentation, a PowerPoint presentation that consolidates the issues. So if it's okay with Chair, if I switch off my camera, and then I will then put the metrics forward. But I'll also give an overview of the observations that have been made in this process. Can I switch off the camera, Chair? Is that okay?
Yes, that's fine. I think I noticed that you do have a lot of comments, and the overview is also very helpful. So perhaps we can just take it and see how people's comfort levels are, but also break in between and allow people to ask questions. Perhaps every 15 to 20 minutes or so.
So the way that I was gonna look at it as well, Chair, was that we are going to flag it, of course. However, I wanted to just give an overview in terms of what we have observed with the with the comment. Yeah.
Okay. All right.
So the document that we submitted is quite long, one, and we are going to flag it, but I would request that I don't read everything. I will maybe just highlight the main comments that are being made by various names and stakeholders, and our responses to the issues. And another observation is that there are areas that are repetitive, meaning that various stakeholders raise the same issue different times. So let me give an example of those. The issue of fair use came up a lot in different submissions. So there will be those who are for fair use because of its many benefits in terms of innovation, its usage in terms of access to information, access to education, and then there were those who were not for. But then you'll find that it appears a lot. So meaning if one had to then replicate the responses for fair use, the document was going to be fairly long. So there are in the responses, there are areas where I say has been responded above, not because it's ignored, because it's a repetition. Another area was on compulsory standard contractual obligations and the powers of the minister to issue the regulations for contracts. It was repeated as well. The third one is on the reversionary clauses, the 25 years reversion, where rights are reverted back to on musical or literary works for the authors. That was another area that was highlighted. So you'll find that where it is raised, it will maybe be handled once and maybe here and there, but not every way. The issue of the economic impact assessment, the CS, socioeconomic impact assessment, was one of the major areas highlighted as well, to say that some of the provisions were not informed. For example, fair use was not informed by the socioeconomic impact assessment, as well as other provisions. Then there were issues around remuneration, where stakeholders were concerned that we are using one model of remuneration across the industries without recognizing their uniqueness. And emphasis being that we are using the model that was recommended by the Copyright Review Commission that was undertaken by the department in 2010 to inform the bill affecting other sectors. So those are some of the major groups of issues that emerged that one will respond to them, but it won't be repetitive. So I will note where they're coming in, but you'll notice that different stakeholders are raising them in different ways, but it's more or less the same kind of response for all of the issues because of the policy positions that we have as a department. So I'm going to then try to, I'm not sure if I have sharing rights. Okay, let me see.
I just want to put it to the member DDG, if that's all right with you, just to have their consensus. Members, are you happy that we proceed with an overview instead of going through the detailed matrix? We can look at the detailed matrix, of course, in our own time, and then after the overview, we can put our questions to the department. I recognize Member van der Westhuizen.
Yes, thank you, Chair. While I realize that the department now needs to respond to all the input received, it would have made life, I think, easier for us if they responded to the various inputs per clause, because it's eventually the bill that we need to consider. But having heard the way they proceed, they've prepared themselves, I think we must proceed in that way. And yes, I quite gratefully accept that we would not be able to listen to repetitive arguments. I think what we've already heard is a very good summary of some of the major points of comment that we've received. So please, Chair, if we can then proceed in that way, I'm happy to follow.
Okay, thank you very much. I do note that the negotiating mandate with the comments from the department have also been circulated, so that can also help to better prepare us as we go into the negotiating mandate. But I do hear you, it would have been possibly helpful to go through them today as well, although an overview does help us to get a more overarching idea of the issues and comments that we're receiving. Members, are there any other responses or feedback? May we proceed? I see none. Back to you, DDG.
Chair, I'm grappling to load. I'm gonna need support on this. I can see the share, but I don't see my desktop. I'm not able to see the presentation from my side to be able to load, to share it. I take it that I have the sharing rights, but I'm having some difficulties. I'm not sure what else can be given to me so that I can do that.
Okay. Zaida, would you mind assisting DDG with sharing? Or possibly asking Lizette?
Yes, I'll ask Lizette, thank you.
Thank you.
So from our side as a department, we would like to thank the Parliament of the Western Cape for inviting the department to this process. I would like to thank the members of the public for taking their time to respond or to raise their concerns with the bills. And we acknowledge that this has been a very long process and a very complex process. We recognize also that the bills are very complex, and all the experts and well-renowned people who contributed to the discussions and the debates, we would like to thank them, because by working together to develop these bills, we will be assisting the future of our creative industries and the copyright-based industries of this country. So we look forward to the next unfolding processes. So I hope I'm able to work on this now. Okay. So I will start. Okay. Yes.
Lizette will assist you shortly. She's just pulling it up now.
Okay.
There we go.
All right.
Good morning, through you, Chairperson. Is this the report that you want to discuss, or is it the matrix that you want to take, that you want to discuss?
It is the matrix, ma'am.
Okay, I will then unshare and share the matrix.
Okay. Thank you.
Proceed.
I can see it. Can you remove this other side where it says the PDF thing? Yeah, if possible. Okay. So in terms of the approach that we have adopted, we brought forward the metrics, recognizing each and every stakeholder or participant in the process who contributed. And how we will then, how I will present it, I will not go line by line. However, I will just indicate where we said the comments are noted is where, say, for example, in this particular A example, where it was said that they appreciate that the bills are providing for, in this particular instance, is freedom of panorama, and then the fair use provision. So this one was not having a specific recommendation for the government or the parliament to say, look into these particular areas, but just to recognize that the areas that they are strongly supporting are around the freedom of panorama and the fair use provision. The freedom of panorama being an exception that will allow the public to be able to take photographs of monuments of national interest like statues, so that those conducts or those practices don't become infringements. So it's one of the amendments that are in the legislation that will assist in terms of that. So this particular stakeholder is saying that they are supportive of this the copyright amendment bill on those two areas, especially because those are the areas that are very, very important for the work that they do, for access to information and access to different areas that they prioritize as an institution. We can move to the next one, please. Okay, I think I missed that. Okay, let me do this on my side. Okay, so the next The next one is on the scholarly horizon, is B. This one also, it was mainly supporting the various provisions in the bill, from the fair use section 12A, and highlighting the other sections, including for other exceptions, such as for education, to say that these amendments are very helpful. They will assist in terms of education, research, for journalists, for news readers, also supporting the freedom of panorama that I mentioned before, and talking to the various amendments related to contracts. And the comment that was made on this submission was around, there's a law that was passed in 2013, is called the Intellectual Property Laws Amendment Act. This act is an act of parliament. It has not yet come into effect. So we make reference to it in the Copyright Amendment Bill. And the suggestion here was being made to say that perhaps we should consider a practical approach to this legislation. Maybe we should remove it and then replace it with a similar type of legislation from another department that deals with the protection, promotion, development, and management of indigenous knowledge. And for this one, our response is that we, because it's an act of law and it's cross-referenced, it is not possible to not take it into account. So because it is not possible not to take it into account, we are not able to remove it from the way that it's linked to the Copyright Amendment Bill. But we have noted this comment about the Intellectual Property Law Amendment Act that is yet to come into effect. And then the next one was another stakeholder. In this one, they were talking about, they mostly supported the amendment. However, their concern was around there should be a registration of copyright. There should be a registration of copyright works. And also that we need to maybe set up a registration portal as government. And they also proposed that there should be education and awareness. That is on the next page, education and awareness related to the Department of Cultural Affairs and Sports with its partners to assist the public, to educate them with workshops on musical and artistics and digital content creators, like to teach on copyright laws and implications and so on. So for this comment, our response is that copyright is it's a right that does not require registration. The right is secured automatically when the work is original and is noted in a notable form. And the minute it's in that form, is in written format, it has that protection. So a person can create their own copyright. There's an international recognized way that can be done by having the word C or copyright, or say copyright reserved, putting the copyright symbol and the name and the year, for example, but it does not have to be registered. And on the education and awareness, this government, we continuously have education and awareness mechanism for educating on our different laws. Even in our side, from where we are, we do have that as a DTIC. We educate on our various laws. So by that point, we noted it. And the next one is D. The next one is D from the Western Cape government. And there were several comments that were made from there in terms of the definitions. We have a definition in the bill that talks to the authorized entity. There were suggestions to say that maybe that definition should be specific on the spheres of government, and that also it should be specific on the issues around the NGOs. What types of NGOs are we referring to? And that should be clarified. And there were some drafting suggestions, for example, an underline in one of the definition on the definition of the technological protection measure, that there should be that, and other suggestions for a semicolon to be added on 10.B. They also raised the issue about the impact, the economic impact assessment that they've noted. One of the notable stakeholders raised it to say there was no proper regulatory socio-economic impact assessment done, and they raised that as well from their side. And then in other exceptions overall, they raised concerns about the fairness of the exceptions and how they will deprive the property of the authors and the copyright owners. And there were some suggestions they also made about some definitions, for example, to define what we mean when we talk about teaching, what we mean when we talk about education, but generally to say that some of the exceptions, like your quotations exceptions, they may deprive the authors, the rights holders of their rightful means, and some of the definitional issues. We noted the submission from the Western Cape government, and I will just be responding briefly to some of those, our reaction or our response to that. So from our side as a department, and this talks to all the other areas in the metrics that will be talking to the economic impact assessment. So by responding this way, wherever you see it, it will be more or less the same response when we talk to that aspect. We noted that this was one of the most important issues that was raised by the public, the concern that a proper economic impact assessment was not done on the fair use and other areas. So our response is that we did conduct one regulatory impact study in 2014. It was not publicized. We didn't put it out to the public. It was just an internal document to assist us with the legislative process around the bills and to strengthen it. And it had an issue of fair use in it, and also this regulatory impact assessment is not a legislative requirement. The legislative requirement is the socio-economic impact assessment system, which was developed by the Department of Performance and Monitoring and Evaluation in the presidency. So they require this one. In February of 2015, Cabinet approved the CIAS, it's called CIAS, in line with the medium-term strategic framework to improve the policy development processes in government. So this the CIAS then became a requirement, and we have a CIAS for both the Copyright Amendment Bill and the Performance Protection Amendment Bill. These CIASs were developed by the presidency. They are government documents. They are from the presidency, not from the DTIC, but they are there. They were conducted. We note the concerns that they are not looking at the current issues that evolved over time, but those requirements from our side were met. And also, we did a copyright review commission. It was established. It was chaired by the retired judge, Ian Fallam, with other commissioners. It looked at mainly issues related to the music industry. It made some critical recommendations, and it was one of the areas, all the studies that informed us. And there were other studies in between that were done, one of them by WIPO, and other studies that were supported by various organizations like universities. So there were various studies done by the department to help us with the bills. So in terms of the suggestions for government spheres of government and NGOs, our response is that the definition of authorized entity is aligned to the Marrakesh Treaty. It does not categorize spheres of government. So we are of the view that as it is in the legislation, in the treaty, it suffices. We don't have to specify the different departments or different spheres of government. And also that the definition does not distinguish forms of NGOs. So we also align to the treaty. So we are saying that we think as it is, we should just leave it as it is because of that reference and to align. And then the drafting suggestions are noted, the underline and the semicolon that was mentioned by the submission. And also there were the exceptions that we are having in the bill from our side as the DTIC and the state law advisors, as well as the parliamentary legal services and other work that was conducted by Parliament, especially with the Professor Sean Vater. We are of the view that the exceptions were found to be constitutional based on various legal advices and analysis. And we are of the view that as they are, they can stand, they suffice. And the other point around the definitions like education, teaching, access, we are of the view because they're in the because they are defined, there are words that are commonly used, they're also found in the dictionary. We don't have to define them in the legislation. And just as a principal point that I wanted to just add is that from a multilateral agreements perspective, multilateral agreements have always permitted countries the policy space to move in pertaining to issues of public interest. The South African copyright law has always had some form of limitation or exception. So these exceptions are not necessarily new. We had some exceptions, of course, in the fair dealing model, exception from the which protects from copyright infringement. These exceptions, they relate to matters of public interest and are not for commercial purposes. So the existing, even the ones that are currently in the bill are not meant to be for commercial purposes, and they have safeguards in terms of the way that they have been drafted. And yes, I understand there's a debate about how wide and how unfair they are, but in terms of the benchmarks we have done with other countries, they are fairly reasonable and they have been found to be so. It should be, in our view from the different legal advice we have, is that they are reasonable and justifiable in an open and democratic society based on the issues of human dignity, equality, and freedom. And we think that they do pass a constitutional muster, noting the concerns about the deprivation of property and so on. So then moving on to page 6 is E. It was also one of the submissions that were very positive in terms of the education sector, and it is urging the National Council of Provinces and the provincial legislatures to urgently pass the bill. So they support the bill. And the next one is a similar kind of submission where we are noting on F, we're noting because the stakeholder is saying that they observed during the COVID-19 how the whole information, the whole sectors that deals with education, libraries were affected. And they are of the view the bill is a great improvement on the current act, and they hope that the legislature of the Western Cape and others will pass the bill because of the benefits of the bill to libraries, research, the sector of education and other stakeholders, and they hope it will be passed. So it was a positive comment, so that's why there are no issues that were raised with it. And on the next one, I'm not going to go into all the areas that Prof. Kachika has raised from the Anton Moster Chair of Intellectual Property Law. There were various issues that were raised, and we thank Prof for his interest in the bill and for the contribution to this process. There were areas that he raised around the definitions. For instance, we have the definition of audiovisual work in the bill that has replaced the definition of cinematograph in terms of films. And his concern was that the effect of this definition and the use of the term in the bill is to create we're creating a new category of work eligible for copyright, and is not corresponding to the changes in the list of works that are in the act currently. And also that it is similar to the one for the cinematograph. And the concern here was that we can retain it because now as they are being used, they can look as if they've got different meanings, but they are similar. So it was just raising a concern about that definition. And also to say that we need to make sure that the definition of authorized entity takes into account the the views of the Constitutional Court judgment, and that we shouldn't ignore them because they should be an analysis of that. And then there were concerns he raised on page 8 related to the broadcast definition, and that there might be omissions, for example, the issue of the program carrying signal as a distinct copyright work, and how it interrelates with the definition of broadcasting. And it seems as if it has been affected, and the way it has been done, we're not really looking at we're no longer looking at the program carrying signal as a means of transmission by satellite within the definition of broadcast. So he had concerns with that. And another concern was around orphan works. These are works where they cannot locate the author, and there's a need to do a search to ensure that the work can be recognized for a particular author. Orphan works, his concern was that the way that we have orphan works in the bill is it's quite onerous. He can recognize the efforts, but it's quite cumbersome process that has been introduced in the act, in the bill. So the other issues were around some of the concepts we are using. For instance, around the usage of the Intellectual Property Laws Amendment Act issues, some of the provisions that talks to that law that has been integrated with that has not been passed. Like, for example, he's saying for Section 7C and 7E that deals with artistic resale royalty right, which is a new form of a royalty. He's asking who is to determine whether works contains an indigenous cultural expression and in which communities to benefit. So this is linked to that issue of that legislation that has not yet been passed. And there were concerns raised about the reference to Section 8A, which deals with audiovisual works in the bill. And his other concern was the way we use the words, for instance, of the words original when we are referring to copies of works, to say the issue around what constitutes an original when you are looking at the technical term versus the other works that when the work is no longer the original copy, but now we keep on saying original of that works. So these are some of the main issues that he raised, and but his submission was we read most of it, and including concerns around the exceptions of fair use on page 11, to say that the proposal of fair use has some consequences, especially around the use of the word such as that has been included, and the examples of fair use that have been added. And yeah, so some of the references to some of the things we are referring to with the fair use, for example, the fact that it's a list of exceptions, and this exception of fair use where we have a hybrid system. So he has some concerns about that, and some of the things that we introduced, and the exception around scholarship and education, that it can have disastrous consequences for the authors and publishers if we include it in the bill as is currently. And also other issues around the Section 12C on page 12. Section 12C on the transient copies, to say that these reproductions don't have to be, they don't have to go further to, which talks to issues of technical functionality. They don't have to go into issues of adaptations. So he's concerned about that. And of course, the issue of the legislation that has not been passed. And he also had some suggestions on wording, like in defining words, like what we mean by instruction, what do we mean by reproduce, what do we mean by incorporate. So even the usages of words like assignment, for instance. So for all the comments that were made, and sorry for the moving forward up and down on this, I'll go back to the responses of the department, and the responses of the department on this, they start on it's on page 7, where we are responding to the concerns of Prof. And there are other experts who raised a similar issue. So when we get to them, I will indicate this is the similar issue that was raised by Prof. And then we'll then go back, and I'll just mention this is where I was. So on the issue of the cinematograph versus the audiovisual work, the definition of audiovisual work has been drafted in a manner that includes we've included the cinematograph films in that definition. And we considered the audiovisual works in order to take into account the current treaty language. We are also of the view that in terms of practices, it's commonly used now than cinematograph. And I understand the technical aspect is raising that we should maybe have retained cinematograph as is. And we also noticed that it's not us only or unique to South African law that this is used. The US Copyright Act also has the audiovisual works. They refer to audiovisual works. So it's just to say that the use of audiovisual works, especially if we say they are the same or more or less the same with the cinematograph. So whichever one we use, it came across with his advice and the other experts that we can still retain the use of the audiovisual works, but noting the concerns that he was raising. And then in terms of the definition of the issue of the definition, not taking into account the program carrying signal. This is now page 8. I'm now at the DTIC's responses on the program signal. It's to say that the intention was not to leave out the program's carrying signal as part of the definition of broadcast as a means of transmission by satellite. If that was unclear, it's something that we can look into. But however, we have also made a recommendation to the select committee in the NCOP that we think that with the developments that have come across related to the definition of broadcast, there's policy work that is currently being undertaken by the other relevant department. And then there are international discussions around the definition of broadcasting as well. So we recommended to the select committee that we think we should retain the current recommendation in the Act. I mean, the current Act's definition of broadcast. So it will then take care of the concern about the program carrying signal and the fact that it looks like we are omitting it, and other related issues around broadcasting definition. And then in terms of the blind essay judgment, we have taken it into account. There has been some analysis and there's work that is being done even in Parliament around this. And those integration of the judgment versus the bill, we will ensure that they are taken into consideration. Chair, I'm hearing a background. I thought maybe there was something being said. I'm sorry about that.
If we just check DD2.
Okay, I'll continue in the meantime. In terms of orphan works, we think that orphan works, as we have it in the bill, we've noted some few stakeholders have raised the concern that it's onerous, it's causing administrative burdens, that is quite cumbersome. We've noted that concern. However, we are of the view that because it's a new amendment, it is an important procedure for those works that are having those difficulties of having been recognized, or where they are not, there's those information missing around them. So we are of the view that the way it is, we think that it's okay, although maybe it looks like it's cumbersome, but we think that it's more or less similar to the model that is being used in the UK currently. They have it, and it's quite extensive in their legislation. It looks at different aspects and similar to what we have. But there's always scope for reviewing, but we think that as it is, it does work, and we think that it should be retained. And then on the point about the original works, when copies have been, they're no longer original, and we still refer to original, we we use this reference to original in the digital rights, especially on the rights of rental, rights of distribution in the different works in the bill. And they relate to those rights, digital rights, and also in terms of the treaty language. So in this page 9, one is just emphasizing where we got the original from. So there is a way that it's explained in the WIPO Copyright Treaty in terms of the interchange of the word copies and original. In terms of the right of distribution and rental. So we try to align to the treaty, hence the use of the wording we have used. And if you check the treaties, they do have that reference. And in the WIPO Copyright Treaty, they clarified in terms of the treaty agreed statement in terms of Article 6 and 7, how the expressions copies and original are applied. So it's because we use that reference from treaties, not because of how we prefer to label it. And then there was a reference that was made to the education and teaching in page 10, education and teaching in terms of subsection 12A, a small a and 4, that on education, that this will have some disastrous consequences. And we tried at some point, we did in the National Assembly process recommend that some of the purposes be removed from the bill. There were extensive deliberations on them, and many other stakeholders were of the view that these should be retained in the bill because of how they will assist in terms of jurisprudence and clarity in terms of what we refer to when we talk about certain purposes. So this was as a result also of public participation, and we think that it should be retained. In terms of the concern about the 12A subsection D, where he raised the concern about it being used for assessing we had the provision that was gonna be used to assess the different exceptions to make sure that they are restricted. We had to remove it, so it's not in the current bill, this one. It's not in the current bill, we had to remove it. So I'm just making a point there that we have noted all the other comments by Prof, and we've taken them into consideration. And so I will stop there in terms of the various areas that were raised there, and then move on to the next one on the performance protection amendment bill, where he made other comments. And on the previous one, related to definitions, I think the same explanation is that some of the words that are commonly used, we felt we don't have to then clarify them in terms of definitions in the bill. On number H, we have the different definitions that Prof was suggesting we move to. For example, fixation, fixation in terms of why we are using fixation. When you have a song that is fixated in a CD, it's a song, or a film that is in a DVD, that's the fixation. So we used the wording audiovisual and sound recording. So he was concerned about the use of those terminologies, and also the other concerns he was raising was around the definition of communication to the public of a performance, that is on page 14. Yeah, and also the concerns about the rights that we have given to in the bill and performance protection for the performers to be able to transfer their works, and also about the producer and the on page 14, sorry, page 15, on the interchange between a producer and the author, where he says there should be guidance provided on who's considered a producer, whether the producer and the author is the same kind of person, same person. And so, yeah, so those were the main issues that he raised. Even the fact that some of the provisions are identical between the performance protection and the copyright amendment bill. And some of the issues should maybe stay in copyright. We shouldn't confuse copyright and performance as rights, the rights in copyright versus those in the performance protection. So to respond on page 13 on the DTIC's responses, we are noting the comments. We have deliberated on the fixation, and we have dealt with them, and they are included in both sound recording and audiovisual works. We were also trying to align with the treaty language as well. For example, the Beijing Treaty refers to the audiovisual fixation as an example. We are also of the view that it's more of the maybe technical language, yes, but we don't think that the rights around this or the protection around both definitions were lost. So we think that both can be used, but we think because the bill is already in this form, maybe we should stick to the current wording that we have. And we think that they are aligned to the treaties, and they also those who need to use them as rights holders can follow them. And we also on page 13 we are saying that we think that obviously the producer and author are not necessarily the same person. Of course, circumstances can dictate that, but we're not referring to the producer as the author. So there's also the copyright owner. I think we are aware of the distinctions. And also on the issue of the performance protection and the copyright amendment bill, that certain rights should just be in the copyright amendment bill and others only in the performance. In our context, both of these legislations are linked, and so we just wanted to clarify that there is no confusion between them. It's just that they are linked, and we think that there is protection and rights that should be provided for performance, and some of them, of course, also linked to the copyright as a right. And also the issue of the transferring of rights, that by allowing this, it's like also we may not be doing service to the performers if we say they can transfer, especially around their moral rights and so on. And just to say, from our understanding, the transfer of right is an economic right, and it's also recognized in international treaties. And the treaties that these bills are aligned to, they also recognize them as some of the rights that the performers can have where their rights are being transferred. So then one moves then to the next submission, which is from South African Institute of Intellectual Property Law. I'll try in the presentations not to mention names of the various stakeholders. I'll just say stakeholder broadly, but this is the next one, is on I. And there were issues raised around the role of the government in giving arbitrary powers to the minister to confer what is a local organization in section 22, and they are also saying it should be withdrawn in the bill. They also raised the concern around section 12B. I think it talks to the issue of parallel importation. I will talk to that point. And they're saying that section must be rejected, especially because there's another section that corresponds to it in the current act that maybe that one should be retained. And also there's a contract override section in section 39. They are saying that it should be that should be rejected. So there were several sections in the bill that they were of the view should not be in the bill. For example, the provisions that are related to the royalties, and that government should come up with workable solutions for authors and performers in terms of their remuneration, but not in the legislation, the way that it is in the legislation, and also to reject the reversion clause in page 15. To reject the regulations or areas where the minister can issue regulations on contracts. They were not in support of the resale royalty right provisions that are in the Act, even the definition related to the art market professionals and the visual artistic works around that royalty right. And so yeah, like for example, the translation section exception that it should be rejected in the bill, meaning it must be removed. And similar to the other comment that on the technical transient exception, on 12C, we should remove the adaptations in that section. It should only apply to temporary copies, because adaptation is a copyright concept and it has got its own rights. When you deal with shifting of formats and you adapt it to different users. And then also they were concerned about the prescribing of the tariffs for royalties, where government can make such prescriptions, like a royalty rate for the music industry, royalty rate for the audiovisual sector. And their view is that it should only be for, this should be limited to the resale royalty right only. And their other concern was around the rights of the minister to on the contracting. Then then those definitions. So I'll just go quickly to the responses, and they raise concern around the Performance Protection Amendment Bill to reject certain sections, especially those ones that are noted there. However, in terms of the detail of explaining the why, we were of the view that it was not clear why they should be rejected. Hence, we've noted them because we saw that they were raised. So for the response on, start on page 15. In terms of the current act for the local organization, the right will operate similarly to what is currently in the act when it comes to international organizations. And so this will just state an international organization, though there is copyright that can belong to the state, that can belong to an international organization. That is their copyright. That is not affecting authors or performers. There is copyright that can belong to a local organization. An example could be an organization that deals with commissioning of research, and they are a specific kind of local organization that can be noted, and then those works then belong to them, not that they're taking them from anybody. So I think in one other submission I saw, they were saying that it could be that author's work is being exploited unfairly, but there is copyright that can belong to this organization, and these provisions are already in the Act, and so far there's not been issues raised around them in terms of any contraventions or any concerns around them. Currently we have them in the Act. It's just that the addition is just going to be for the local organization. And then on the powers of the minister to issue contracts, because there were many provisions where it was recommended they be removed. We are of the view that this is meant to create an enabling environment. I think there's a section where I'll talk more in detail around contracting and why we recommended it, and from which research has informed that, and so on. We are of the view the powers of the minister, they are meant to create an enabling environment. The minister will not sit with parties, role players, and dictate what should be in a contract. The law just creates a framework where there are minimum requirements that should be in a contract. It is important for rights holders to know what should be constituted in a contract, because there has been issues in the past where many people contracted unknowingly. They signed off their rights without knowing. They didn't know what a contract should look like, what provisions or terms should be in a contract. So as government, the intention is just to assist in that creating of that enabling environment. And also the unenforceable contracts, when one is the legislation says one thing and then a contract contradicts what the law says. Those contracts, the bill is saying they should be unenforceable. It's a means of protection as well for the right holders. So if those rights are violated or they're not adhered to, that's where this protection comes in. Then it becomes unenforceable. And we see this as an additional protection. On the royalty rates, we note that currently they are not legislated, and we thank the comment. We think that this is a point that should be taken into consideration with the rates. There has been challenges in the past in the industry, especially the music industry, where there has been I think there was a court case at some point around this establishing the appropriate rates, but we also think it's something that can be left to the market. The rate that can be prescribed is the one for the resale royalty rights, not for all the rates. So we note that point, and it's a point that we have also indicated to the Select Committee. We think that it can be reviewed and it be limited only to the resale royalty rights and allow market forces to determine in terms of the rates and the contracting parties and so on. And we also rate, yeah, I think that's the point around that. And we also recommend that the issue of adaptation, the point about adaptation is noted. It's another recommendation we have indicated to the committee to say we think it can be removed also to align to other laws and maybe to also for it not to be seen to be having extra effects of taking the rights from the rights holder or the owner and so on, where now there's also adaptation involved in that process. So the copies are recognized, but then maybe the adaptation issue can also be considered for removal, and something that we have recommended as well to the committee. There was a concern raised about the freedom of panorama, section 15, subsection 1, to say that we have it there, but it has not been repealed. And from our understanding, it was just a substitution. It was just to strengthen the provision. So it was not repealed because of that. It's a drafting issue, that this one. And there were concerns about the strong technological protection measures and the fact that the current measures are not adequate. The reason why they are the way they are, they were extensively deliberated. In fact, there were these additional provisions added in the technical in the TPMs to make sure that they're strengthened, similar to other countries that have done the same. However, we received strong advice from experts to say that the current TPMs in other countries, which we are trying to follow, have not succeeded with those TPMs. There are challenges with those TPMs, which had more serious consequences for the usage of some of the permitted uses of copyright. Some of them had health implications, where someone had to use something, but they couldn't because it's locked, or there's that serious barrier to entry to have access to that kind of information, which could have assisted. And also, we found there could be competition implications and consumer protection implications. So we then thought, as a country, because this is new, these are new provisions, we are a developmental state, we still need to maybe see how we develop this area. So it's one area that I know many stakeholders have raised it strongly to say we don't provide, the bills don't provide adequate protection, adequate legal support, but legal remedies. But these were seriously considered, and this is how the final outcome was. And in terms of the other concerns about the Berne Convention, especially related to the resale royalty rights, we will consider looking at the issue around linking it with the Berne, because it is part of that convention, and a possible review around it is something that we have proposed to the committee as well. So we've noted that concern, but the concern that it should be the section that deals with the resale royalty right should be in a separate chapter is also noted, but we think we will look at ways to review what is currently in the bill and see how best to improve it. But it's something that is also in the hands of the Select Committee. But as a department, we've recognized that comment. Now on J, page 18, sorry, 19. On J, there were comments made, but J also, the comments were in support. It's a group of experts, academic experts. They were in support of most of the provisions of the bill. There were some advices that were provided, starting with the constitutional judgment around the blind essay matter, to say that we need to make sure that there is that alignment. We must not have interpretation issues with the judgment versus what is in the bill. They made some proposals, for example, the deletion of the word prescribed in section 19D1, and also to look at some of the restrictions of the scope of application of these provisions for section 19D that deals with persons with disabilities, to make sure that we align, especially on the authorized entities that serve the persons with disabilities, in terms of what could be allowed and what should not be allowed. So they did give some advice around that, and some of the wording that can be removed from the bill. Like, for instance, they suggested that where we refer to subsection 1, in subsection 2, we need to remove that, talking to some of the entities that will be prescribed. So they made some suggestions also to remove any ambiguities or confusion between the different subsections in section 19D. And also moving from section 19D, they were of the view in page 20 that we should retain the position of catering for all forms of disabilities. There are certain policy objectives that the department has taken that are meant to support persons with disabilities that are additional to what is provided in the treaty, in the Marrakesh Treaty. So, for example, we cater for all forms of disabilities, while the Marrakesh Treaty only focuses on persons with who are blind and visually impaired only. So, and also we extended it to other works, not just the works that are provided in the treaty. So we have extended it a little bit more. So those are some of the areas where other stakeholders are of the view we have extended the treaty, and that we are not aligned to the treaty. And then there's concerns were raised about deleting of section 28P subsection 2 because of the restrictions that can come from the technological protection measures that may hinder accessibility for persons with disabilities to access certain works, because of the way that that section is drafted. So there were suggestions that to be aligned to the spirit and of the court judgment, that should be deleted from the bill. Then also they suggested the addition to add informational analysis as one of the purposes in section 12A, that we should add that informational analysis, because when new research methodologies come in that allow computers to help researchers to be able to read and analyze information, including for copyrighted works such as books, this will also assist if this is considered. So they suggested that we add this informational analysis after research in that subsection. Into page 21, the emphasis there is to say they were suggesting that instead of strong penalties related to infringements on the digital rights and also on the technological protection measures, consideration should be on having civil liabilities rather than criminal liabilities. So that's one of the recommendations that we made. So, and they made some drafting suggestions and some draft around that area. So I'm gonna go to then talk to our responses as a department on the issues that were raised around this particular submission on page 18. And our position on the section 19D is that we support that we include all the works and that all forms of disabilities be retained. So this then goes beyond the minimum of what the treaty provides, and we are saying that we support that. And also the different wording that they suggested, we will be looking at them, including the issue of the prescribed. We were of the view that because of the nature of the authorized entity, the word prescribed, although there could be other providers of accessible format copies for persons with disabilities, the word prescribed then also means that there is work that needs to be done by government to ensure that we we know who these entities are, and they are also credible entities and so on. So it's something that we will be looking at with with the parliamentary legal services to see how best to integrate that judgment with this, or taking into account those issues. But we've noted that there are recommendations to delete it, but it's one of the areas we will be working on to ensure that we have a proper alignment. We support the recommendation to delete 28P2, especially if it's going to cause challenges of accessibility and hinder the access to persons with disability, especially on the exceptions. And also the referencing issues that were raised, we have noted all of them and we'll make sure that they are taken into considerations. And on the liability versus criminal versus civil liability, from our point of view, already on the technological side, cyber crime related issues, on the protection of copyright owners and authors, on issues of protection of their works, many feel that the bill is not strong enough, and that at the same time there are those who feel the penalties are too strong. But according to the international discussions we've been following and the discussions we've had with other regulators and other bodies globally, there has been concerns that our intellectual property legislative regime and enforcement is questionable, like it can be strengthened. So we think that the current provisions in the bill can be retained. That's our position for now, but this is an area we can still look into, but we think that given the concerns around that, maybe that it's an area that can be retained for now. So on the issue of the computational, the other analysis, the reason why we are of the view that that should not be incorporated, we note it because it's one of the additional purposes that can be included. But then we also saw in the submissions, many stakeholders were saying, government included a lot of purposes in copyright, in fair use 12A, and so many that are even beyond what the US, many compared it with the US one, to say the US only has this many and South Africa has added so many. So we are of the view that maybe for balance, we shouldn't add more things. And also taking into account that having the phrase such as permits that other uses can be added in over time without necessarily putting them verbatim on the document. So we think that some of these uses are implied, they can be brought in without necessarily changing the law all the time, adding different issues on the list. Of course, the concern that this helps with the clarity of what we are referring to, and also in the courts, it will help with the courts also to deal with the issues, because then they will be clearer in the act. But we think that for now, we shouldn't add further issues around that. So now it's K, page 22. The comment there, most of them is just to support the amendments, and also to raise a concern about the opposition that the author has seen against the bills, and the concern that what could be the motives behind that. But they recognize the importance of the CAB for the students, scholars, researchers, and leaders, and access to information. So the comment is mostly just to, it's a comment of support and acknowledgement. So it doesn't need a response. So we'll move to L. On L, there were various concerns that were raised. One of them was around the wording in the definition of broadcast, to say some of the words that have been used in the definition of broadcast do not necessarily make sense. And they also raised a concern about the link with the program carrying signal and the issue of the satellite. Like it does not look like it includes that. And they were also talking to the current definition in the Act, that perhaps that definition it should be retained. And also the concern also with the overlap between the performance protection and the issues around the audiovisual works and the copyright amendment bill, that there should be some kind of consideration about having issues of performance in the copyright, that maybe that should be looked at. So they were concerned about that, to say that there should not be dual statutory legislation where you have got one legislation dealing with two laws at the same time. They recommended that the deletion of performance protection issues from the Copyright Amendment Bill. And also they had some issues with some of the wording around the royalties, the use of the word execution, for example. And then there was that concern I mentioned in the overview about a single remuneration model, to say that different sectors are not the same. There are ways that, say, for example, literary works and how the remuneration models work, and they will differ also for the television sector. And that's one area that they brought in, even in terms of how they operate commercially, and that there shouldn't be a single model of remuneration, and that the current royalty provisions as they are from section 6A to 8A are not workable. They had concerns with them. Also the issues around the model use of royalties, that not every royalties cannot be similar for all types of works. And that was one of the areas they raised a concern about, around the royalties. And just going forward, they were having suggestions around the role of the copyright tribunal, that the role of the tribunal on the royalties. And then there were concerns with the reporting requirements. I'm now on page 26. The reporting requirements, to say that there is these provisions that are criminalized, where there's a need for those who use works for commercial purposes to be able to keep records and to assist with the payments of royalties. So there's a reporting requirement, and there were concerns. They raised concerns with those reporting requirements, and also concerns with the provisions that talks to the commissioning of works, where a work is commissioned. And they made suggestions also on the drafting of the commissioned works provisions. They raised concerns about the powers of the minister on the contracts, that minister should not be given such powers to make such contractual requirements. And yeah, that these powers it's been given too much powers. And they suggest that also on the rates of remuneration, rates of royalties as well, that those should maybe be deleted from the bill. And yeah, so most of their issues were around even the role of the tribunal. And there were additional comments that they made that are not in the bill, in terms of providing more protection in the legislation. And some of them are related to internet-related crimes. They proposed that provisions be added to streamline the removal of takedown and site blockings, just to make sure that those issues are dealt with. So we've noted all these comments from this stakeholder. And yeah, so I'll then go to the responses by the department to those specific issues. And the responses, they start on page 23. So on the definition of broadcast, I did touch on it a bit before. So it's just to say that we've noted these comments about the confusion with the definition of broadcast. We aligned the broadcast definition to the treaty, and we note that some of the words that are in the definition, stakeholders are saying some of them are not clear. So we take into account the policy processes that are currently underway, and we also take into account the international discussions around this treaty. And we have recommended that for now we use the current definition that is in the Act, and we hope that in the end that's the final thing that will be there, so that all these other issues that have been raised are then taken into account. So we think that we can look at retaining that, also taking into account all the concerns about the program carrying signals and so on. I'm now on page 24. the last bullet there. So our view on the dual statutory of using copyright and performers together, having performers in the copyright, our response is that both of these legislation have been integrated from the way they have been drafted from the onset. They are linked. It's not something that has just started now. They are linked, and we also, even if you look at the format of the current act, when it talks to performers and performances, and as it was reviewed over time, there has been that linkage that was there in terms of the two legislation. And we also looked further that in terms of these related rights, which are rights for performers, producers and broadcasters, sound recording producers and broadcasters, in other countries, they have them together in one legislation. So you could have both in one law. So instance, in the US, in the UK, they are incorporated in one, and not just these two countries as an example, other countries as well. So it's not an anomaly to have that. So that's the observation that we've made, and also noting that there are countries where they are separated, where you have copyright and you have a separate right. So we think that as it is now in the copyright amendment bill, and it's in line with international practices, and also in the format that is existing currently in the Act and the performance legislation. So there is that linkage anyway. We noted the concern about, now I'm on page 26, the concern about the remuneration model. We've noted that, and we think that the what can be maybe considered, and which we propose to the select committees, that instead of just talking about royalties, especially on section 8A on the audiovisual works, we could also talk to equitable remuneration. So we think that by adding equitable remuneration, it will then at least take that concern into consideration. And the reporting issue, just to talk to it from a policy perspective, because there were concerns about the cumbersome provisions on reporting. We found that the non-reporting has been a serious issue that has impacted on many performers whose works have been played in different platforms without them being recognized. And from what we have heard and have consulted upon, this is a prevailing practice, and it was recognized in the Copyright Review Commission as one of the issues. That was a finding on page 27. We've noted that to say the commission found that there was a need to have log sheets and that they should be kept by broadcasters, and that music users, they must retain them, so that there could be those mechanisms to be able to pay royalties. So this has been a challenge over time. And although this was talking to the music users or music industry, with the different consultations we had and discussions we had with industry and various groups of industrial players, we realized it's a very big issue. We have performers, actors, actresses who have come at some point to the National Assembly Portfolio Committee to say they see themselves, even in SADC region, their productions, but they don't receive anything. So it's a fact. It's a fact, and I know it's something that maybe it sounds a bit controversial, but it's a fact. It's a problem, and because it's there, that's why we have these provisions. If I recall, when the portfolio committee discussed it, it was extensive discussions, and they wanted to at least tighten the legislation, because there are many persons, some of them are no longer in this earth, they are gone, who have not received royalties, and their faces are all over television, different platforms, and that's where this reporting issue is coming from. It's got a long-term historical context, that it's not just a matter of having like a burdensome process where stakeholders says it's quite administrative. It's got other implications, and that's why the committee took a long time in these debates. But it's something that I thought we should bring in just to say there's a rationale, and it's a policy rationale that brought these processes, all these provisions to be where they are. So it's not a music industry issue only. It's a creative industry, especially in those sectors where there's reuse of works and for commercial purposes, and there's no resulting payments of royalties. And then on the commissioned works, there were issues raised with commissioned works. On this one, although we did not see the specific areas that could be considered for review, we thought we should bring in the context of why the commissioned works was looked at the way it was. So there were challenges that were raised about commissioned works. One of the examples is where the copyright owner, the person who commissioned the work, or the person who commissioned the work uses the work for purposes other than what it was intended for, or the work is never used at all. It lies dormant, for example. So some of the provisions that were added in that commissioned works and the use of a contract to establish the ownership, or to establish the relationship to a particular work. So the strengthening of the role of a contract was one of the items, and then also the role of the author in what happens to the works, and also the role of the tribunal when it comes to the licensing, or when it comes to the different challenges that are raised by the author when it comes to the work that has been commissioned. So how it was also another area of extensive debate, the issue being that it was meant to add more protection and adds to strengthen the current provisions, to make sure that there are these measures in place to deal with the issues of the commissioned works. And now to the page 30, the issue of the powers of the minister. So as indicated earlier, that these issues of contracting, various areas in the bill, especially the Copyright Amendment Bill, that talks to contracting and where the minister can prescribe. We have similar, some of them in the Performance Protection Amendment Bill. As indicated, these were meant to create an enabling environment. So there was a recommendation that was made by the Copyright Review Commission. It was saying that there should be, because of the unfair contracts that were affecting the music industry at the time, they proposed that the minimum requirements should be set by the minister. There should be that in the bill. They recommended that, but then with our research, other research consultations, hearing from different industry role players, and the issues of unfair contracts, unfair exploitations, there was a need to look at it beyond just the music industry, because contractual issues cut across. And because of these practices, that's why we have different provisions that talk to contracts. And the contract issue, another thing that should be highlighted is that it could be informed at the prevailing time by market forces. So let's say in the next 10 years, and the bill is there, the act is in place, there are issues that come across in a particular industry that requires ministerial intervention. There could be a framework provided, or regulations, or something to assist. So it's something that is discretionary, but it's meant to assist with market failure. It's meant to assist with the gaps in the market, but it's something that is not, it's a discretion. It's not like it will be there. It's something that is a discretionary, but it's just to make sure that those minimum requirements are there. And I've spoken a bit on the unenforceable contractual terms as well, to say it's also there to assist, because sometimes the act will provide, and then some role players will not take that into account. And it applies also to the some of the guidelines or the specific issues raised in the various royalty provisions in 6A, 7A, 8A, because it was said that some of those are problematic because they talk to the issue of the the contracting. The tribunal is also very important, and the tribunal will come in very strongly to ensure that disputes related to contracts, disputes affecting the rights holders are taken into account. We also checked in terms of international best practice. Is it common for government to have contracts where they make requirements or some kind of minimum guidelines or standard? And we found that it's not unique to the bill, the Copyright Amendment Bill or the Performance Protection Amendment Bill. These things do come across in other countries. I think Germany is an example that we saw. And in terms of there was a proposal that there should be consultations with stakeholders for more than 45 days. And we noted it. And there are times when we make, as from our side as DTIC, I'm not speaking for government as a whole, where we will publish regulations for 45 days. So we've noted that proposal around the number of days for consultations. And there were concerns about the role of the tribunal, whether it can impose fines, whether its powers can make orders, and our view, and hoping that we understood their context properly, our view is that we have tribunals currently that do so. They make orders. And some of them have the same powers of the High Court. They make orders. They can even impose fines on juristic persons, not just natural persons. So we think that it's something that can be dealt with by the tribunal, depending on the powers that it's being given. And I must also add, we currently have a tribunal in the CIPC with limited scope of application. It's not a strong, it does not have all these provisions or powers that are now being provided in the Act, in the bill. But we do have, but it's very limited in terms of the focus it addresses. Yeah, so there were proposals that were made that were additional. I mentioned one on the ISPS, internet blocking. Some of these, because of they are new and they will require a new process, consultations, and so on. We thought that we noted them, but we don't think that we can be able to incorporate them now at this stage of the legislation and where it is. There were comments made in the Performance Protection Amendment Bill related to the definitions of the performer, of the producer, and also the fact that there should be extras. There should be an exclusion of extras in the definition of performer. From our understanding and from what we understood from other industry role players, they're saying that there's an understanding in the industry that performers don't include extras, that extras are not entitled to royalties. And also in terms of the treaties, performers, the definition of performer does not even have that caveat of excluding an extra. But when we presented to the Select Committee, we did say, even though we know that it's not, we don't have to add it, but for the purposes of public participation, we could request that they look into that, maybe took advice, saying something about extras, maybe as a subclause on extras, but in terms of practice, they are not included. And even in the language of the treaty, there's no reference to extras. So we think that the way the definition of performer it's in line with the treaties, and we don't think we should exclude extras, but because it's been raised repeatedly, it's something that maybe can be reviewed. Moving on to the next submission. Yes, Chair. Yes,
I'd like to propose, we've been going for quite a while now, and I imagine you might also need a bit of a break. If I can propose that we have a 10-minute break, reconvene at 40 past or 20 to 10, just so everyone can have a bit of a breather and then come back a bit refreshed.
Thank you, Chair. Noted.
Supported.
Okay. Thank you, members. We'll see you again in 10 minutes.
Thank you, Chair.
break to get a coffee and are feeling a little bit refreshed. So we are ready to resume. I'll hand back to TDG.
Thank you, Chair. Thank you very much. I will continue. Chair, I hope everyone can see the document. I'm on page 33.
Yes, perfect.
Okay. So the next stakeholder, just to acknowledge, it's a very well-renowned expert in copyright, well-respected across the sector. And I wanted to just acknowledge that and to thank him for his contribution to the process and for adding to our knowledge and yeah, in terms of making things work for the legislation in the country. So in terms of the issues that were raised in this particular submission, there were issues around the legislation I mentioned, the Intellectual Property Laws Amendment Act, where he raised various issues around the points about that law. And he even said in the submission that where he will be referring to it a lot throughout because of its implication and how it has been applied in the legislation. He was concerned that there's so much reference to it, but it is not in effect, it's not being implemented. And also he raised a similar issue around the work, the wording, audiovisual work versus cinematograph film. So it's similar to the discussion I had earlier about the interchange of the two words, which are more or less a synonym, but then why remove cinematograph film and use audiovisual work? So I won't repeat most of it because the debate is more or less the same as what has been raised before. Even the context to say maybe we should be using the cinematographic film rather than going into this audiovisual work. And also in terms of the various implications from his side of what that could mean. And then there was another point raised about the definition of broadcast and the link with the program carrying signal. So, and the fact that it's referred to as a work. And so there were the debate around it versus even he added the point about the computer programs as a work when it comes to these cinematographic films and the definition of broadcasting. And in between, some provisions talking to the legislation that has not yet been implemented, like your national trust. The law does have some platforms or structures like your the trust, like the national trust, the community-related infrastructure that is in that other legislation that deals with intellectual property of traditional knowledge or indigenous knowledge. So, for instance, issues around the definition of the wording traditional work. He's saying that there's no definition of such, even in the Act itself. So there were various issues he raised around such, and also some definitional issues like your visual artistic work and the issues around drawings and how the works apply, and views around also the original, the one that I had before about the original works when it comes to the rights to distribute, even issues around the rental, but the issue of original when it comes to distribution of works. So I'm just showing the various issues that he raised and even the issues around the royalties. What we mean by royalty, for example, and his concern of the way the wording has been used in terms of what it means in terms of pricing and in relation to profits and the copyright works. So, and there was a notable point he made about the author and the copyright owner not meaning the same thing. That you can have an author and a copyright owner, but it looks like we are maybe the way the drafting is, where we refer to author on the royalty provisions. It seems there's a confusion about that. So there were various comments made by the stakeholder related also to the Section 8A and how it applies. and also the role of the tribunal, the role of the companies, the CIPC, the commission. And so some of them were, he was very detailed, like it will be the same kind of comment on one area, it will be on another royalty, and then also on the other law that I mentioned. And some of the wording that we are using, like the word shared, meaning when you say shared, it means the owner and the performer must have the same amount, you know, so that certain things was raising that are conceptual from a technical point of view. In terms of the fair use, his concern was that the use of the doctrine is foreign to our jurisdiction, and it has no place in our legislation. And he also was talking to the current fair dealing regime in the Act, and that the fair use does not comply with the three-step test, which is a Berne Convention and a TRIPS convention, or a principle or a frame that is provided by those treaties, which helps in terms of how copyright works, especially exceptions should be utilized, and in terms of their exploitation, in terms of their usage, to balance the interest of the public versus those of the rights holders. So he had concerns about fair use, and also a concern that there has been a misconception about him referring to fair dealing and fair use as the same kind of concept, that he does not hold that view. So so clearly in his view, we should mostly retain fair dealing, because he says this is a foreign concept that of fair use. And there were other areas the way he raised concerns, like the provision that deals with parallel importation, especially to say that we don't have any rights to regulate when it comes to other jurisdiction. Here, talking to the fair sale doctrine that is incorporated in our copyright law, to say that that provision, we should look into it, because it brings that doctrine. However, it might be confusing the way that we have attended to it in the bill. And then he raised various issues towards the end around the Marrakesh Treaty, and the Section 19D on persons with disabilities. He is of the view that it should be aligned to the judgment of the Constitutional Court and be limited in its scope. For example, it shouldn't be for all the works, for instance, and it should not be for other forms of disabilities. It should be limited to the persons who are blind and print disabled. We have widened it, and he's of the view should not have been like that, and that it does not comply with the three-step test as well, the way that it is in the bill. And there were other conceptual issues that he was talking to, like your assignment, and you know, how we are using the wording of assignment, and the role of the commission, how it's being applied in the bill, and the role of the copyright tribunal. So most of the issues can be read forward in terms of the concerns raised. We try to incorporate as many of them as possible to recognize the advice and the guidance that was being provided to this process. And one will then go back to where we responded as a department to the issues. I'll try not to repeat the areas that we've already spoken to in the previously. So in terms of reference to the Intellectual Property Laws Amendment Act, we are not able not to do so, because it is in the statute books. It is a law of the land, and it has to be cross-referenced, because if it's not cross-referenced, it might cause other challenges with the listing and the sections of legislation that has to be taken into account when it comes to this legislation. So it's something that we cannot avoid. We noted the concerns about referencing it, and it has never been implemented for more than 10 years or so. So we noted that. And then the same principle response is the one we give on the audiovisual works versus the cinematograph. We give the same response. I've already spoken to it, to even say that in the US they use the same and that we try to align to the treaty and the current language principle around audiovisual work versus cinematograph, and also to say the cinematograph is already included in that definition that we have of audiovisual works. And what we like is the fact that the experts have indicated they are like synonyms, meaning whether you use one or the other, it does not seem to be too much of a hindrance. So we don't think that we are moving too far from what is the right approach when it comes to this issue. And then on the issue of the original versus distribution, it has already been clarified. We have aligned to the language in the treaties around what is a copy and what is original. So I won't repeat that, but I've brought back that point in this response just to align to make sure that it has been taken into consideration. The issue of the author and the copyright owner is noted. They are not the same thing. You can have an author who's not an owner. You can have an owner who's not an author. And it's an area that we are also advising or recommending that from the select committee point of view, they look into that as well in terms of the wording to ensure that there's that clarification. So it's noted, that point. So on the issue of the, let's see, yeah, we'll look at the wording. On the fair dealing and the fair use, we have found that many countries, even those who are, they call them Commonwealth countries, they have fair dealing. However, there has been a notable observation that there is a move towards having more wider exceptions to facilitate development in various countries. So it's not an anomaly to have a list of exceptions and the fair use provision at the same time. So while we note the fact that fair use is a foreign concept in South Africa, we think that as it can work for the greater good, especially for our developmental context. And we also think that it's not abnormal for us to have exceptions and the fair use provision put together. So we note his concern about the nature of this provision and the fact that it's something that maybe should not be in our legislation. And from the work we did with the department, with the minister, with our legal advisors internally and in Parliament, the issue of the three-step test, that we don't align to it. We have found that the bills have been found to be aligned, but this is a debate, and I know that many stakeholders will not agree with that, but that's how we have understood it, to say there is that. And at some point, the committee had an expert who came to give an opinion or a view on this, and they produced a document about the three-step test compliance of the exceptions, and we think that there is that alignment. The commission definition, it is there, and the role of the commission, but it's provided for in the Intellectual Property Laws Amendment Act. And the bill is clear also in the transitional provision on how to address the definition of commission and issues that are still pending from that legislation. On the term of royalty, we looked at it, considered it, and we are of the view that royalty is a commonly used term. It's also used in the treaty and is recognized internationally. And we did not find anything of concern when it comes to the definition of royalty. And we have noted most of the comments made, especially with the tribunal, but we think that the tribunal has a bigger role to play in balancing the playing field in terms of the copyright legislation, also for balancing the interests of different right holders and providing a cheaper mechanism for dispute resolution and redress. So the different comments that have been provided on the tribunal have been noted, but we think that the new the strengthened provisions will go a long way in assisting in these processes in the legislation. On N, the stakeholder was mainly in support of the CAB, and also the way it recognizes various authors and its the role it will play in education research. They only had one point about the persons with disability, the provisions to align with the court judgment when it comes to the technological protection measures provision. And I've already spoken to it to say we have recommended to review and remove that because of the hindrance it might have on that provision, and also on Section 19D and what the persons with disabilities can have access to. So we do support the recommendation or their suggestion to remove that. And then O is similar. We note the comments. It's our artists who have written a submission to request that the CAB and the performance protection be adopted urgently for the sake of royalties, to address issues of unfair contracts, and to make sure that their issues are taken care of in the economy. And they jointly wrote the submission to say that they support the different provisions that will enhance the works of the creators, and including on the commissioned works for photographers and the different role players in the legislation. And it will also enable the visual artistics works to benefit. And yeah, so they were in support. So there was no comments that needed further consideration, and we have noted their submission. P, it's another submission that looked at the concerns around the fair use provision, that it's a foreign concept from the US as well, and also. So the fact that the wording in the fair use, it deviates from the fair use that is commonly used, like the US, meaning the South African fair use provision 12A, section 12A has gone beyond the US. And then there were concerns with the contractual rights and the powers of the minister to prescribe contracts, and the reversion clause, where we say that for the literary or musical works, the work can be, after 25 years, the right can revert back to the author. So they had a concern about that, that the timing of it might be a concern in terms of how the assignment then take place. And also the fact that the way it's being recommended is not in line with the recommendation of the Copyright Review Commission. They also raised a concern about 12B subsection 6 of the parallel importation, and that it should be rejected by Parliament. And yeah, so they also raised concerns about the issues of royalty rates being prescribed by the minister, you know, and then talking to issues of the socioeconomic impact assessment, to say that there was no socioeconomic impact that was done, and for different provisions of this legislation for the bill, and concerns about the 28P2, which they raised it from a different point of view. The way it was drafted, it was like permitting unlawful acts, like to hack the works of the rights holders. So there was a concern of that section. That section will be looked at, especially from the accessible format copies, access to works. There was also a concern with the technological protection measures, providing adequate legal support or legal provision, I mean the adequate remedies. So in general, their recommendation is that the bill should be rejected in its totality, and that there should be a proper impact assessment done, and that there should be an independent legal opinion from experts on copyright and the constitutional law. So to respond to the concerns that they are raising, we noted the concern about the impact assessment, and also for the general exception of fair use. And we are explaining why fair use and how it works and the 4 factors that are there to ensure that it's got safeguards and that we think that fair use as a model it's a model that has been recognized and that it works in other countries that are progressive and progressing and also in the public interest. And we explain a bit about our hybrid model that has been adopted by the Portfolio Committee in the National Assembly and the list of exceptions and other countries that have adopted it. So it's just to say that it's not unique to South Africa, although other experts argued not many countries have adopted fair use, but there has not been any country found to be maybe in a legal battle, maybe let's say in the World Trade Organization about the use of fair use. And those that use it seem to be doing very well from the creative industry perspective. And yeah, so the current system is fair dealing, and it looks as many of our stakeholders in the publishing industry, book industry, they prefer that we retain the fair dealing that we have currently in the current dispensation, on the current legislation. So on the parallel importation, the TRIPS Article 6 does allow exhaustion of rights and for the country to choose which system of exhaustion, which then determines how the parallel import will work. So this talks to section 12B subsection 6. It has been raised a few times by stakeholders on it should be deleted, it's confusing, it also conflicts with another provision that has a similar kind of a provision. The term exhaustion refers to the principle in intellectual law to the, that a right holder cannot prevent the further distribution or resale of the goods after consenting to the first sale, also known as the first sale doctrine. Once the good has been put on the market by or with the consent of the right holder, further circulation cannot be controlled. So parallel imports refer to the original product sold by the right holder or with his consent in another market and then imported through a channel parallel to that authorized by the right holder. So we are saying that these are not pirated products or counterfeit goods, and they don't infringe intellectual property rights in the country of origin or in the country. We are also we take into account that they will allow distributors and booksellers to choose from a range of world markets as opposed to only the South African market. So it will open up the market, which could lead to a more equitable pricing structure. And it will open access to cheaper copyright works abroad. So what we have also seen is the issues around competition in the marketplace when it comes to the books. The issue of competition is evident from price of the pricing of books in the country. So we think that the national law should therefore follow the rule of international exhaustion rather than the national exhaustion. And we have noted that maybe there could be areas of review. We can review section 12B subsection 6 and maybe look at how we can clarify that. So it's one of the recommendations we have made to the committee to see if we can look at this closely, just to try to accommodate and to work around challenges around that provision. So it's an area that we think we can look at further, especially the 2 subsections talking to the same. The other section is section 23 subsection 2 of the current act, talking to a similar issue. So the next one is Q. The next submission is from Q. The stakeholders there, they also had a concern about the fair use and the fair dealing, and that we cannot use the same system at the same time. Their view is that the 2 are not compatible, and that should the committee be steadfast or be intend fully to implement this, then there should be statutory damages introduced in our legislation to cover for the harmful effects of the fair use provision. So on that note, our response is that, as has been addressed before, that it's not an anomaly to have both systems and to have a list of exceptions with the general exception of fair use. There are countries that have that, and also those that are in fair dealing are starting to open up, have more flexible exceptions. So we think that it's a norm. It's not something that is just foreign to South Africa. That's our interpretation. And also the concern that our judges or our law may not have experience on fair use, so they will not know how to deal with jurisprudence on fair use. Our view is that we have noted several judgments. There is jurisprudence. There are matters that have been handled by judges on fair dealing in South Africa. So there is some kind of experience around dealing with issues around these regimes, and we think that that concern might be circumvented somehow. And also on the statutory damages, our view is that we think that it's a different model to what we have in our legal system, while we note the fact that it has been recommended by several stakeholders to see it as a way to balance the harmful effects of the exceptions. We think that there's a need for further engagements around this one, and also we need to look at it further before we incorporate it in the bill. The next stakeholder is on R, and in this, the emphasis here is about the advent of technology, artificial intelligence, where you could have robotics having copyright or acting as humans in some respects. The concern is around that the recognition of the evolution of technology when it comes to copyright and how it will impact on the future legislation if these issues are not taken into account or at least noted. And also the recommendation that there should be an additional purpose added in the bill for computational analysis and machine learning. So to say that should be maybe considered for addition in the bill. So to suggest that we add informational analysis. If you recall, there was another comment that was similar around that, and that copyright has been extended historically to humans, and efforts to extend copyright to outputs from non-humans, they have to be rejected. So that's I think the fundamental point that is being made here, and that they wanted to bring this to the attention of Parliament. To deal with this matter now, because it's an issue that might be an issue later on, especially when it comes to the advent of technology and the artificial intelligence and the developments in the digital space. And our response is similar to before. We think that with the purposes that have already been added, that have been queried, we should not add further, but this one can be taken to say the way that the bill is can accommodate additional purposes without necessarily having them listed, because we already have that, such as expression in section 12A, and also that we note the recommendation about the artificial intelligence, and that they are shedding light to us about the use of technology. But our view is that this is a new amendment and it's quite extensive. It may require further work and consultation. So we think that we will consider it for further future discussions around that. But we note it as one of the areas they wanted to bring to the attention of Parliament. The next stakeholder looks at both bills. Some of the issues have been raised before around the definition of performer and the role of extras when it comes to remuneration, and also in terms of international best practice, and also that the audiovisual works and performers should be removed from the copyright amendment bill. They raise concerns with the 25-year limitation for assignments of rights, that it should be deleted from the bill. the powers of the minister for contractual for the contractual minimum requirements regulations, that it should be deleted because it's interference with the normal ways of working, productions, and so on, and the impact on investment in the country. And then the reporting, I spoke to issues of reporting on why they should be reporting. They are concerned about the imposition of the registration, and that is too comprehensive, administrative burdens, and that the punitive sanctions they might affect the market. It might turn off the market, and also they were suggesting how the sharing of royalties should be dealt with. They're concerned about the way that the royalties are like a one-size-fits-all for all rights holders. They're concerned about the reversion right. And just to quickly respond to the issues that were raised, so these were the main issues that they were raising, and I've clarified about the extra in terms of the performance and the understanding in the industry and the treaty language around how the extra is treated, but the fact that we have recommended to look into that, that the Section 8A of audiovisual performance, the integration between the Copyright Amendment Bill and the performance, that they are already linked. There's no need to really remove them, and also some of the additional rights that are in the Copyright Amendment Bill will assist performers, especially with the other platforms like your tribunal, the collecting societies, and so on. And we noted the concern about the 25 years reversion period being short, and to say that comparing it to the US, which is like 35 years, our understanding is that the US one is longer because of the period of copyright in the US, which is 70. It's linked to 70 years. So that's where we think we've noted the concern, but we think that 25 years is a fairly reasonable time period, especially coming from the Copyright Review Commission recommendations. But we also think that the concerns with the reversion is that parties can always renegotiate their terms of contracts or agreements, and where there are other discrepancies, like some stakeholders raised that there could be more people involved and you need to find them, and we think that we could also look at possible regulations around this issue. On the ministerial powers, I won't repeat that because I've clarified about the powers of the minister to create an enabling environment, and it's not to impose and to interfere in contracts, but to give that a guideline to create an enabling environment. And then the remuneration model issue has been addressed because we are going to consider adding, especially for the audiovisual sector, the expression audio equitable remuneration to accommodate other modes of remuneration over and above a royalty. The next submission is T. On T, the main focus is on Section 19D, emphasis also on the court judgment and the Marrakesh Treaty, and some suggestions of wording that should be considered. I've already spoken to most of these issues before from other stakeholders, so I'll just focus on the response from our side to say that we agree with the submission that to accommodate other forms of disabilities, and like hearing impairments, dyslexia, and other forms of disabilities that requires further support for accessible format copies over and above the Braille. And also that the suggestion of permitted entities, we thought, although the court judgment recognized it, we recommend that we use the authorized entities to align to the Marrakesh Treaty language. And we will continue analyzing the judgment and the subsections where there are changes recommended and where there might be inconsistencies. We'll be working closely with the legal services in Parliament to ensure that they are thoroughly taken care of or addressed. The analysis have already started, and we've been engaging, consulting on them on these areas. And I think overall, the 22 subsection P of the technological protection measures, we've highlighted it. We have recommended that it be deleted as well. The next one is U. On U, there was a proposal on the improvement of the definition of dramatic works. There is a concern that the way that it is in the Act currently does not take into account the way that the works around this. It's not taking into account the other the way that the dramatic works is being approached, the market, how it works, and we don't recognize these role players the way that they should be recognized. And I think that the distinction of the works, that we might be looking at them as audiovisual works, but they are more distinct. So that point has been noted for further consideration. There were other issues raised around the definition of producer, and then the contractual issues around the powers of the contract, the minister to issue out contracts, the 25 years reversion, and the limits of that. So we've noted there are concerns around that, and the fair use. The concerns with the fair use and the potential exploitation it may cause on the legitimate use of the rights holders. So we've noted their concerns. So we have recommended to the committee, select committee, to look at reviewing this definition. We've noted the proposed definition by the stakeholders on this. It's an area we will be looking at. We think that the definition of producer as it is in the law currently in the bill is sufficient, and we think that it can be retained because it aligns to the treaty language as well. And the other issues of contracts, the reversion, they have been dealt with in the previous submission, so I won't go into them further. And then the next stakeholder, V, number V, deals with issues around both bills, to support them and to support even the areas that other stakeholders have raised as concerns. For example, the royalty rights, they have the view that it's going to go a long way in assisting, especially for the audiovisual sector, and also the 25 years reversion. They think that it's going to go a long way to assist and to deal with the abuse of these provisions in the future, to deal with abuse around contracting, and also to ensure that there will be fair contracting. So they support both legislation, and we have noted their comments. And then there were number W has made comments, and most of the issues around deleting of the contractual provisions, the automatic reversion to be deleted, also the fair use exception to be deleted, the concerns with the audiovisual sector to remuneration, and the implications of that for productions in South Africa and how it will impact on investments. There were exceptions that they raised as concerns about how they should apply, and the fact that they don't align to the three-step test, and the concerns about the technological protection measures, that they are not aligned to, they don't have adequate protection. So most of these issues came forward before as well, and one will not go into them again, except that for the quotation, because they raised a specific concern about their quotation, that it should be limited to one industry. I think it should not be too wide, the exception provision, so or exception. And our view is that this was considered in the process, and in our case, it includes all the works, and we think that this should be based on fair practice, and we think that it will be this will also be used in a manner that is fair, and we think that it can be retained. The next one is X. Yeah, they raised the issue around the fair dealing and the fair use as one system. and they're also concerned about the way that the whole process is unfolded, and they would like that the process, maybe it needs to be reviewed, and that there's an issue around the jurisprudence of using the fair use doctrine, that we may not be in the best place to come up with this kind of regime, and fair dealing is a system that is more preferred. Yeah, so then, and also the issue of the socioeconomic impact assessment, that it was not done, that we have not provided Parliament with those documents, and that the definition of accessible format copy does not allow to Marrakesh. This talks to the way that we have expanded it beyond the minimum requirements, and some advice around how this then should be treated to ensure that we are not found wanting in terms of international law. Yeah, so so some suggestions around section 19D, and then there were certain amendments that they were referring to that based on the previous submissions that were in Parliament, not this current bill. So I will not go into the details of them, but I will then talk to the responses to those specific things that have been raised by this particular stakeholder quickly. So in terms of the fair dealing, fair use concern, because we have dealt with that, I will not repeat that. But then on the ephemeral use, they used the previous submission in Parliament, where we were looking at the possible Canadian model to model with that exception or use, to make sure that, or that right, to make sure that they address issues of timelines. So in terms of what is this ephemeral exception, it's currently in section 12, subsection 5 of the Act. It's limited to the musical or literary works. So they form part of exceptions, and they allow a broadcaster to have a copy of the work, such as a sound recording, for a limited period of 6 months without being allowed to distribute to any person. So what happens is that you'll have a live event that is being broadcast, and there may be a copy of the music that is being played in the background. And this allows broadcasters the right to use those recordings in their reproductions without paying royalties. So this is a temporary use. Yeah, it's a temporary use, and it's for 6 months. And then the Act talks to how it can be, this can be stored. So the other provision of 12A subsection D was removed from the bill. It was in the previous advertised provisions that were there to deal with issues of exceptions and how they can be measured to ensure that they are tightened. And there was a concern about the digital rights, to say it should not, when we bring offenses for the digital, like when somebody makes available the works to the public or communicates the work via internet or any digital platform, that is not allowed or is an infringement, that initially it was only for commercial purposes, but then the bill currently is widened to look at both commercial and non-commercial. So that amendment has been taken into consideration. It has been attended to. And the three-step test for the incidental technical uses in 12C were also in the previous advertised clauses, but they were removed eventually because a lot of concerns were raised that you cannot have a three-step test as a principle or policy or a framework in a legislation. So we then those were then removed in the consultation process in Parliament. The next one is submission Y. It raises issues around the CS, the lack of the CS, and then it talks to the expression of such as. They have a concern with such as, to say the portfolio committee inserted it, and it creates that a problem of broader uses, and it's going to cause other challenges because it also goes beyond the way that the US has done theirs. They are suggesting that the committee, the NCOP, must reject the exceptions, general exceptions for education, computer programs for libraries, they're saying they should be rejected, all these exceptions, because they will cause challenges for authors and copyright holders. They will cause some challenges there for them. And they are also calling for a team of international experts to be assembled to ensure that these bills comply with international treaties in their general schemes. They also raised the issue of the Marrakesh Treaty and that it may not align to the issue of international treaties, that there's a way that it has been addressed by the bill that is not in line with national treatment. So our response is that the such as that was seen as inserted by the Portfolio Committee was one of the clauses that were opened up for further consultation. The president did raise a concern about consultation of fair use, and such as was one of the issues that were raised. So we think that as it is, it does cover many purposes, but there was a concern about it as well, that it is a concern the way that it has been addressed in the bill. And also, when it comes to national treatment for the section that deals with persons with disabilities, we recognize that there's a need for uniformity with international rights and international law. We see the bill as being more in line with the Constitution because it provides more rights for people. And the way we read the Marrakesh Treaty, it does not prohibit countries from dealing with their own issues of policy and development. And the treaty gives countries, national governments, the guidance on ensuring support through their legal systems and practices, economic situation, social and cultural needs to persons with disability, and ensuring availability of accessible format copies as well as other rights. So we see our bill as in line with international obligations. Also, there are researches that were done, studies done by experts to show there are many countries that have moved and added more rights and did more than what the Marrakesh Treaty provides. So it's not only South Africa that has done so, and there are studies that have proven that. So the next one is Z. Z raised a lot of concerns around the Performance Protection Amendment Bill, around the exclusive rights of reproduction. They raised issues around the reversion that is a bit similar to the one in the Copyright Amendment Bill, and some of the rights that are being permitted in the Performance Protection Amendment Bill, including the right of the minister to issue out the standards of contractual terms, and the implications for contracting, and some of the sections they propose should be deleted, including for fair use. They are recommending that be deleted. So they made some suggestions around the different provisions in the Performance Protection Bill, especially around the rights of the performer. And we looked at those issues, we reviewed them, and our view is that we think that while we note their comments, most of the issues that they are raised have been addressed. And we have not noted specific areas like that should be amended in terms of the bill as it is currently. But we have noted their comments. Also noting the comments AA from the Western Cape. So in the comments, most of the comments were in support of the Performance Protection Amendment Bill and also the Copyright Amendment Bill, especially on issues of education. And there were issues raised around the distinction in fair use, to say fair use should differentiate works for music composers, for photographers and other subsectors, that there should be that distinction in fair use. yeah, so that was the main comment that one has noted. And our response is that fair use is a general exception, and the bill guides in terms of how it can be used with the factors. And then that we think that there could be ways that the work is applied, the way that it's applied without necessarily having those distinctions that are being proposed. So we note the comment. The next one is BB. On the BB, there is a concern about that there are the recognition that there are different subsectors in the copyright-based industries, and we can apply one size fits all for them. For example, the audiovisual sector is different from the others, and then the concern about the 25 years reversion right, and the implications it will have on the audiovisual sector, and the lack of an economic impact assessment, the fact that there was no meaningful impact assessment that was done, and the bills will have far-reaching implications as they are, and then also in terms of the role of the tribunal. So there was a concern about that, the way that we are bringing in the changes and the uncertainty that this the bills will bring. And so yeah, so most of the and then the role of the advertising industry, to say that the advertising industry should be excluded from some of the provisions in the act, especially section 8A that deals with the audiovisual sector, because they are unique, they're not similar to the sector of the to the audiovisual sector. They don't have the same model even of remuneration in terms of the how they deal with remuneration. Another issue they raised was around the reporting requirements, that now they'll be required to comply with that reporting requirement, which was never intended for sectors like theirs, and these issues around the royalty regime and entitlements. So their concerns were around those areas of remuneration, the different modes of remuneration by the different industry segments. So they feel that the bill will have negative implications. So they recommended the rejection of the royalty provisions, given their implications on their sector. So from our side, from our response, we think that currently the royalty provisions that have been strengthened, we think that the royalty model was intended in the Copyright Act, and so even the performance protection, even though it was limited in how it has been, current provisions strengthen them. It's just to strengthen them. And we also note that the provisions provide a royalty regime that is going to be more concrete even for future purposes, and they will provide more protection for right holders. And the contractual issues, we think that they are very important, and they are not intended to take away any protection. But to have a provision in the legislation that excludes a sector, we think that for now it's something that is not advisable. I think there could be ways to manage how issues are dealt with, arrangements in the sector, but not necessarily to have a provision that excludes one sector amongst the other sectors. So we don't think that it's something that can be dealt with in this bill, especially for Section 8A. So the next submission is CC, and the issues around what they've raised around the contracts, the socio-economic impact assessment, the contractual override, where the violation of a contract and then that won't be enforceable, the issues around the 25 years assignment, the powers of the minister that are overly broad. They also raised an issue about the local organization issue to say this will be exploited if minister is given those powers to prescribe an organization. It will affect the authors and so on, and concerns about the sharing of royalties. So they want the NCOP to reject the royalty provisions. So they also are against the fair use provision. They see it as a permission to have free use. So they've raised concern about that and the fact that the protections that are provided in the bill are not sufficient. So our response overall is to say that we think the bill introduces provisions that bring a balance in the digital environment and also protection of rights holders. And we've noted most of their concerns, and most of them have already been responded to in the previous submissions, because they talk to similar issues. And the next one talks to the is DD submission, and the concern is that the fair use provision does not talk to the three-step test of the Berne Convention and the TRIPS, and that the exceptions and the fair use and the fact that there's this contractual arrangements that are provided for in the legislation and in the bill is going to exploit the work of the author. So they are concerned about that, and that there's a use around performance of public administration that is being included as one of the uses, and they see this as possible abuse by government that will abuse the uses of authors. And yeah, so there is a moral right issue they're raising about where we need to always recognize the author, and to have a phrase such as far as is practicable is a concern for them, because it's important to acknowledge, and this is a cornerstone of copyright. So they are raising it for section 12D that deals with education, subsection 8. And then the overbroad exceptions is a concern for them that deals with education, general exceptions in terms of the intellectual property and the deprivation of property of the copyright owners and the authors, and concerned about the use of the word such as for fair use. So these comments have been noted, and our responses on them is that as indicated, we found the fair use to be incompliant with three-step tests, and also in terms of not violating international law. On the public administration purpose, it was deliberated upon, it was found not to be problematic, and it will also be looked at against the factors that are there, that are in the fair use section or exception. And we think that as far as practicable is one of the safeguards that is in the bill. It has been considered on a new subsection or new exception, especially on the education purposes, but it's not widely used like your fair practice. Yeah, or as far as possible, it's not used like that, but it's one of them. But we also recognize that acknowledgement is important in copyright works. The author is a very important person, so we support that. But then there are instances where the author cannot be found or it cannot be identified. So I think those instances also can happen, but we do acknowledge that the acknowledgement of an author is very critical. The exceptions were consulted upon, and they have been found to be constitutional with and they are also in line with international law, and they have their own safeguards. So they were also found to be in line with the three-step test. So we think that the concerns are valid, but we think that a lot has been done to try to circumvent the challenges. EE is another submission, they're raising issues around the contractual freedoms that will be implicated or impacted by the bill, both bills, and that there should be contractual flexibility to cater for production, distribution, and remuneration, and that there was no impact assessment, and that there should be enforcement mechanisms introduced in the legislation. Also, that the technological protection measures don't provide sufficient protection. And those comments were noted and also addressed in the previous submissions. And then the next one is FF submission, number FF. The submission supports the education exception, and also that supports the bill in general, but they are saying that fair use must differentiate authors and authors of academic and educational works and other works. Yeah, so it's just to recognize that fair use can be differentiated according to them. And they also proposed a subsection 12E to deal with that. And they requested local content to be supported. Local content, the principle of local content, where you have requirements for how much local content should be played in a particular platform, whether it's radio or television, especially in radio. So in terms of the concerns about the fair use, we've noted it, but in terms of international best practice, the distinctions have not been noted previously. So we think that as it is, there could be ways that fair use is applied if it's adopted as part of the way forward for the Copyright Act. But then without necessarily having to be saying for composers, fair use for composers, fair use for actors, fair use for, so we think that it should be kept as broad as it is, but then how parties apply it, they can work around that. And in terms of local content, this was in the original, I think the initial draft bill, there were debates and discussions around local content, but it was then decided that with the work of the department versus other departments, it's more suited for another department than the DTIC. So that's why it was then not taken further in the legislation. So it's one area that should be taken up with that relevant department. The next submission, GG, raises issues around the CS. And then they say that, for example, the royalty for the literary or musical works, it's a problem because not all works can succeed. And also they raised the concern with the prescription of royalty rates, like to say to pay this royalty, it must be 5% or 3% determined by government. And then the issue of the powers of the minister for contractual arrangements. The concern was also raised by the fact that there was a study done by one of the stakeholders in the publishing industry, and they say that government did not take that study into account. And our response is that there are diverse issues around the bills, especially Copyright Amendment Bill, and different industries have got priorities. Because of the diverse nature of the industries and concerns that they have, we note when they bring different inputs to government, but we also try and strive to be independent so that we don't seem to be leaning towards one direction or the other for that balance in terms of our role. So the other submissions here, I think they were noted, but they were oral, if I'm not mistaken. So there were no submissions there, but there were oral submissions, but just to recognize the names of stakeholders who contributed to this process. And then we get to NN, number NN, so that they raised issues around fair use, and their concern was that our fair use is different from the US. They even had a table highlighted in terms of the differences of the US and the South African fair use style. some of the concerns about the use such as the such-as, which they recommended should be removed from the bill, and the fact that the purposes that have been incorporated are more than the ones that are in the United States, and that there should be wider consultation. There was no impact assessment that was done, and the concerns with the roles of the collecting society. So there were certain recommendations made related to collecting societies that were noted. There were several provisions they recommended should be redrafted or deleted from the bill. And yeah, so the concerns were noted, and the fact that they still need further consultations on the work with relevant experts. So if noted, they are concerned about and they raised an issue on the principle of reciprocity that has been included when it comes to the issues around the collecting societies. So to respond to the concerns briefly, we think that the collecting societies we noted the suggestions on the collecting societies, but we think that collecting societies have been provided for, and we also think that on the issue of reciprocity, we needed to make sure that it is provided for in the bill. There could be ways that contracting parties or the different societies they match make between themselves, but this was just to ensure that there is a framework, but it's something that is not compulsory, meaning that it can be a consideration for how it can be taken into account. So they can look at collecting societies that align to the way they do work, and consider sharing with them. So then they can have those reciprocal arrangements. But it was important that it is catered for in the bill, that issue of reciprocal arrangements. And we note the comments from the submission number 000 and also number PP, which raised concerns with the reversion rights of 25 years. And there was a suggestion to consider, and the issue of the temporary technical 12C. Yeah, so there were some suggestions around that, how it should be used, and also the fair use, fair dealing model, concerns around that, and yeah, so generally it was broad issues around commission works, how the uncertainties around the way that it's been drafted, and even the private copy levy should be introduced, and yeah, the comments around the resale royalty rights, and so that there should be more measures brought in for protection against anti-piracy, that there should be consideration around the safe harbor to deal with issues of the value gap related to big technology company that can exploit the works of the performers, authors. So all the comments were noted. I think on the one that we are touching base on is on the private copy levy, to say that we noted that model of the system of the private copy, especially on the personal usages, and that we note that other countries are implementing it. However, we also noted that there might be challenges with the application of that regime of private copy. So we are of the view that more work is needed to look into that. We noted the other concerns, comments, especially the new ones that are not yet in the bill. For example, the value gap and the safe harbor provisions that other stakeholders are recommending be added in the bill. And let me check who's the last one. The last stakeholder is QQ, and they were saying that on the assignment that there should be consideration of the distinction on literary works, because there is functional literary works and utilitarian literary works, for example, tables and compilations. So the suggestion is that there should be that distinction that is provided. And then also for computer programs, there was a need to do that distinctions between the creative works and the utilitarian works. So to distinguish the different types of literary works. So on that point, we note the comment that has been made. And we think that maybe those distinctions can be dealt with in the contractual arrangements, but we don't think that at this stage they should be then added in the bill, in the context that is being proposed. Chair, this is the last one. I know it was quite a mouthful, but thank you for your indulgence and the time. I know it took a bit long. This was the last. We've noted as many comments as we can, and we hope that it will assist in the next steps of the process. Thank you very much.
Thank you very much, DDG. Our procedural officer has advised that she did send through 2 oral submissions. I just want to confirm if DTR did receive them.
Chair, the 2 oral submissions, when were they submitted?
Zahida, if I could just call on you.
Thank you, Chair. They were submitted along with the template for the matrix, all the submissions.
From the list that we were working from, Chair, unless there was an omission from our side, from the list that we saw, we did not see them, but it's something that we can correct. They can maybe send them through email. We looked at the link, and the ones that we have highlighted, because we were even given that table. And if you look at that table, there is where they say oral submission. So so when we looked at the list, that's how we thought it's oral. Maybe that's why they're not there. But we can maybe get them, those 2, or the list that is there, and we can quickly respond. We can maybe send through the responses separately.
Okay, thank you. If you could double check, and if you haven't received them, then we can definitely resend them on to you. Members, with that, we'll now move on to the deliberation. So my proposal in terms of the deliberation is that we can use it as an opportunity to make any comments or ask any questions to the department. We have until 12 o'clock. So what I would propose is we can take questions with, let's say, 3 questions per person per round. Are there any hands? It's very unlike this committee to be quiet. I'll give it another minute to see if there are any hands. Okay. DDG, I think you did a very good job in terms of answering many of the questions that otherwise would have come about. I do have a few myself, so if you'll indulge me. With regards to the economic impact assessment, I wanted to get a better understanding. The document that was created in 2014, which aspects of the industry did it look at? And then also with the CS, when was this completed and when was this circulated to industry?
Thank you, Chair. The study, the impact assessment, it touched on the different sectors. It also looked at, for instance, there were some things said about the education. There were some slight things said about, I think, the publishing. There were some references to the treaties that we need to comply with, but it was amongst the other studies that we worked with. So I would not say that everything, the sectors that we have here, were included in that, but it touched base on some few concepts here and there related to the issues. So it also talked to the issue of the fair use in broad terms, and it provided that sense of there should be that consideration on the fair use. So we found it to be a very useful a study that also gave a sense of the issues that are linked to the bill. So we did note that it was not, we did not put it out in the public domain. We did not put it out in the public domain, so it was not published. Hence, some of the stakeholders did raise a concern that we did not put it out for the industry to see it. And so it is not widely recognized, but it's one of the work that was done by the department around this. For example, in that study, they talked to issues of the parallel importation is one of the areas that is being addressed. There's some reference to publishers. So there is a bit of work that it tried to touch on to look at some of the issues. The musical sector also, it touches on it briefly in some respects, and also issues of the artistic works. So I think it was fairly broad, you know, and especially some of them, they came through the they came through the treaties, referencing of the treaties, and issues around the performers, and it recognized various sectors. Yeah, so I think to some extent there was some effort in that impact to be a bit wide as possible. So it did look at some of those some of the sectors, and in terms of the socioeconomic impact study, we did do the socioeconomic study, and we did share it with the portfolio committee. We did share that study with the portfolio committee, and I think in terms of the when, let me not say specifically in terms of when it was done, but I know that it's one of the studies that we finalized to support the bills. It was then dealt with in terms of addressing the both of the bills were supported by these CSs that were also shared with Parliament. I think it was in 2015, if I'm not mistaken. They were both dealt with in 2015 as the two of the documents. But I stand to be corrected here, but I think it was in 2015, before the bills were then introduced to Parliament. But we started those processes as far back as then. So when we went to Parliament in 2017, the CS were already there in terms of the timelines. They were dealt with before then, before we approached the parliamentary. Before we approached Parliament. So I think it was in 2017, but it's something that I will just double check for the purposes of accuracy for the committee.
Thank you. I do note that there is a hand from Tebogo, but I just want to flag at this stage that the purpose of today's meeting is essentially for the members of this committee to deliberate. We are not having a public engagement, so to speak, as we've already concluded the public hearings. Tebogo, could I just get clarity on your hand?
Yes, can you hear me, Chair?
Yes.
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 No, Chair. Yes, I am aware that the public hearings have concluded, but as you rightly say, and stated that it's for the committee, but perhaps what I'm going to say will assist the committee in its deliberations as we move forward. Unless you don't want to indulge me, then that's fine, I'll understand.
Perhaps, Tebogo, just for the sake of time, if you don't mind using the chat function, just so we can get through the list of questions that we need to get through.
No, that's fine. I've had made some comments already on the chat
Okay,
box. Thank you.
we'll make sure to have a look. Thank you very much.
Thank you.
Member van der Westhuizen?
Yes, thank you, Chair. And first, my apologies. There's been some construction work, or shall I rather call it demolition work, being started on a property next to me, which makes it quite difficult first to concentrate, and I hope it doesn't interfere with the sound as well. Chair, through you to Dr. Masetla, and really I want to congratulate her on the detailed responses, also the enthusiasm that she's still showing after such a long period. May I first just share that, unfortunately, our experience has been that at this stage, when the comments of provinces are being sought, that it doesn't simplify matters, it doesn't streamline matters, and unfortunately our experience in the NCOP has been that they find it very difficult to really affect changes. Secondly, I get the distinct feeling that although there've been a long time and a lot of negotiations and talks and working groups working on this, that another round of such talks would have added a lot of value to the final product. Now, to my questions, can I just ask, in terms of the powers given to the minister, and unfortunately we're only sitting here with the amendment bill in front of us, to what extent would things such as the nature and the percentage of the royalties or the contents of those contracts, to what extent would it have been possible rather to have a draft for consideration by artists and producers, people that produce intellectual property and that produce copyright documents or copyright, can I have a wider term there, items that should be protected by copyright? To what extent would it have been possible not to prescribe, but rather to assist by providing a template or a document with best practices or guidelines to avoid artists or those creating copyright items to be guided by that and not to be prescriptive? Because it seems to me as if we've had numerous comments on that, and that seems to be one of the points where I think a further round of discussions would have been able to perhaps just give a little bit more freedom for both those that produce and those that want to make use and will have to pay the copyright to come to agreements which are not that prescriptive. Thank you very much.
Thank you very much. I recognize the hand of Member Nkondlo.
Thank you, Chair, and thank you for the presentation, quite detailed. And I think in the midst of the technical information, one may ask maybe something that was explained, and pardon me if that is the situation. Because I think one just has a number of concerns at a general level. First, about what is the hold up, and this hold up has got everything to do, in my little understanding, with I think some of the uproar concerns, especially from the creatives themselves and the extent to which what is the intention of the bill to try and support and protect particularly local creatives and artists. You know, the intention is there, but the devil is always in the detail, because amongst others, and I think in some of the presentations or the public hearings, we have had, you know, some of these concerns from the local artists themselves, you know, in the finer detail, especially around issues of fair use, you know, and how restrictions or not, flexibility or not, in that actually impact, you know, what could be benefits to the artist. And I'm sure in as far as that continuum is concerned, it may be very difficult to actually get to the actuals. But I think what is important, I think from myself as a lawmaker at this point, is to make laws that reasonably, you know, provide a fair sort of maybe benefit is not the right word, but I'm hoping, colleagues, you would understand me, to all those that are involved. So I think that is just one general notion that I wanted to raise, that what's the intent of the bill as presented, I think, by the department, is noble. But what I find is actually the actual match of that in the finer detail. And I think those that are in the industry, both I think the production houses and big players, have made their own presentation versus I think our local artists, the small new entrants that are growing, on how you create that particular balance. And that detail, I think the concern is exactly on that particular detail, if indeed it rises to the occasion of meeting those intentions set out for this amendment. And why I'm assuming, and perhaps the colleague from the department can actually further explain this, you know, this delays of this bill, because it's been years. I think we've been talking, or this bill has been, you know, up for its conclusion. But further than that, Chair, I think two issues, and that's why I made the disclaimer earlier on, that if it has been answered, maybe in the technical detail, I might have missed it, and my apologies. I just wanted to know the extent into which actually the coverage in the IP for scientific and technological inventions or inventors have actually been strengthened in the bill, you know, in particular if we talk about the notion of fair use. So that at least, you know, the big tech giants with infinite legal resources to cushion them, you know, against IP infringement liabilities, you know, that at least those smaller guys at least have got recourse. What is that, if it is there? And if it was explained, I'm sure perhaps I could be indulged further in that specific one. I'm not reopening the public hearing, and I think also this issue of fair use, also in as far as literary works, particularly where it comes to, you know, availing that to, you know, education, particularly to schools and all of that. How has the department, you know, responded to that outcry for those that would have raised that? I just needed to understand those two, Chair, in the bigger scheme of the explanation that the department has done. Thanks.
Thank you very much, Member. I also have some follow-up questions and then I'll hand back. So just in terms of the CS policy then, is it possible to get an explanation of why this document wasn't shared to the industry and whether it can be shared now? I know it is quite a late stage of the legislative process, but I think it would provide some clarity to the industry who've asked a lot of questions about it. And then I understand that the department has explained they feel that they have had a lot of engagement with the industry. But in our public hearings, we did receive a lot of complaints from those in publishing and in film, amongst others, who complained that the bill in itself doesn't deal with specific provisions relating to their industry, and it takes more of a blanket approach. And they attribute this to a lack of an impact assessment, and how, for example, fair use might impact on film or publishing. You referenced the Farlam report. It would be great if that could be shared as well. But the Farlam report is also criticized for focusing heavily on the music industry and ignoring all the others, again, being responsible for taking that blanket approach to policy. So if I could just get some guidance on those questions as well. Thank you. Back to you, DDG.
Thank you, Honourable Chair, and thank you to the honourable members for their questions and comments. On the question or the comment about the guidelines for contracts versus the compulsory requirement and the powers of the minister, I note that concern. And if you recall from the presentation I gave on the metrics, it came up a lot from different stakeholders. And I note the concern that maybe there could have been or there should be more engagement with industry around that point. From the rationale that has been provided, the reason why it was approached in this manner is because currently in the creative industry, in the creative sector broadly, there are issues related to contracts, unfair contracts, contracts that are exploitative to the different role players, your authors, your performers, and so on. So which made the issue of contracting very critical. And yes, the Copyright Review Commission mentioned it. It did look into it, although it was rightfully so focusing on the music industry and the role of collecting societies and their governance. But with the various consultations, we also realized that there are concerns even from the other sectors, like the audiovisual sector, related to your performers who are in the sector in terms of how they are the abuses of unfair contracts. So that came across even from that side. So that's why then it was prioritized the way it has been in the legislation, especially on the issues of royalties and also the minister's discretionary power to be able to come up with those regulations, standards in terms of how the template of a contract should be. So this is where the rationale was to say, let's look at strengthening issues of contractual arrangements. Let's look at how to strengthen how the parties do engage from a contractual point of view. The way we interpret it is that minister will not be directly involved in terms of where parties sit and make their contracts. The whole process is to just create an environment, an enabling environment, by ensuring that when you contract as an author, as a new entrance in the industry, you know what a contract should have that talks to your specific rights, and to have those minimum requirements provided. So that's the rationale. But it is not for minister to impose or be party to those contracts. It's just to create the guide or sort of an enabling environment in terms of how the contracts should be applied. So that's the response I would give to that point. But I do note the point about why not guidelines versus what is currently in the bill. The seriousness of the issue dictated that it is approached in the manner it has been approached. But it doesn't mean that we don't recognize that many stakeholders received it in a way that looks like it's an interference on their contractual freedom. So I will then step to the next point or questions that were raised around the details of the bill. Honorable Nkondlo raised a concern about, although the bills, they seem to be having very good intentions and objectives, people who are supposed to benefit from them, some of them are raising concerns. And I think the issues are diverse, Honorable. They are diverse because others raise, depending on where they come from, they're raising, others will raise concerns around the royalties, that they have not been receiving royalties. Then there will be those who raise the concern that our industry is not the same. You can't treat us like the musical industry because we are audiovisual sector, and we've got different model of how we operate, how we are remunerated. So yes, we have highlighted them, and even the stakeholders have highlighted the diverse issues that they are confronted with. And part of them is this issue around how the minister's powers are in the bills related to contractual obligations. There are provisions related to reversionary rights, where certain rights will go back to the author after 25 years. So some stakeholders raised those very strongly. Fair use is another one you mentioned as well. The fact that fair use is going to open up the industries to exploitation and the illegitimate usage of their works. So those are some of the concerns that have been raised extensively. In terms of, has there been enough deliberations on them? Obviously coming from government side, and with the deliberations that started as far back as 2009. So we think that this has been very long-term engagements at different points in times, including the work that was done in Parliament from 2017 to date. So our view is that there has been extensive deliberations, and even outside we've had engagements with stakeholders, but obviously depending on where the bills are now, different stakeholders or industry role players will look at it differently to say their issues are not sufficiently catered for. But we think that most of the discussions have been held over time on these bills and has been extensive. Yes, and then on the education around fair use, because fair use is a doctrine that is now being introduced in the bill, we haven't really started with the education and awareness around what is some of the provisions and all the provisions in the legislation, because the bill is currently underway. It's being it's not yet a law. It's being undertaken. So, but if it happens that we have a law and it has fair use, obviously most of these issues will then be brought forward to the public, including around the issues of education and so on. So it's something that we will look into in future, but because we are still in this process, I would say we haven't gone into that. Other issues were raised by the president when he returned the bills. These bills were adopted by both houses before they were returned by the president. He raised constitutional issues with them, and part of them included the consultations on fair use, some of the royalty provisions that were retrospective. So the issues are quite diverse. He raised concerns with the wide exceptions, mentioning some of them specifically. So yeah, so there were various issues that were also raised from his end around the issues. I think the previous issue I forgot to mention is around the royalty rates. That point has been noted by one of the stakeholders, or some of the stakeholders, to say minister should not prescribe royalty rates for royalties, and we recognize that it's an area we need to relook at. We have mentioned it to the Select Committee in the NCOP to say maybe they should be limited to a particular type of royalty, like the resale royalty right, not all royalties. So we are hoping that it will be one of the areas that are attended to during the processes. And on the issues of fair use and possible infringement, we think that the current provisions as they are, they can, with the safeguards that are already in the bill, and the factors that are there for ensuring fair use, we think that they could play a role in balancing out how this the usage of fair use. We also think that some of the safeguards that are in the exceptions would also assist. And from a technological point of view, some of the measures that have been added to the legislation, such as the technological protection measures, even though some are of the view they're not strong enough, we think that they will go a long way in assisting in these processes. And on issues of redress, the role of the copyright tribunal, I think it will come a long way as well in terms of addressing some of the issues that may come up on the potential disputes that may be coming into this to these processes, or when the legislation is then implemented. In terms of the CS and why it was not shared with industry, Chairperson, we can avail the documents to the industry, but when we do policy work as government, we do engage with the public, but there are certain documents that we work with that help us to make certain decisions, and they are not always required to be publicized in public domain, like you put them in the newspapers or in websites, but we can maybe share them with the Western Cape Parliament for those stakeholders that have raised concerns, then they can be distributed to them. But we have been engaging with stakeholders throughout the processes. And yes, some of the engagements have not been easy, but I guess it's part of the legislative process. It has got its own challenges that come up in the process. The point about the blanket approach to industries, we've noted that. And I think in some of the approaches we are proposing to address them in the bill, there are certain recommendations that we have also brought forward to the Select Committee to say, for example, on the remuneration rights, how do we deal with remuneration issues? The impact assessment on fair use, impact assessment on the bills, the current bills, that's a different discussion, I think. Yeah, we are of the view that there has been sufficient consultation, there has been provisions have been informed by either research, best practice, engagements, but it is open to debate in terms of to what extent. So I will stop there, Chair. Thanks.
Thank you very much. I would really appreciate if you could share those documents. If you have access to the Farlam report as well, would be very grateful if you could share that too. Members, are there any further questions? If you could kindly raise your hands. Okay, I see no hands. Okay, I do have some more questions. Please bear with me. My first question is, I just wanted to get an understanding in terms of the legislative process and the research around it. What is the usual process or the process that should be followed in terms of commissioning a study, commissioning a CS? I understand that changed throughout the duration of this bill, but I'd like to know kind of what is the real ballpark here. To me, it does seem strange that the research was done in 2014 and then the legislation was in 2017. To me, it feels a bit like putting a horse before the cart and setting up your policy initially so that your legislation follows that. But I'd like to just get from you an understanding of how the research is usually conducted in a normal legislative process. Then in terms of fair use, it was mentioned that there were international benchmarks conducted and comparisons. And I would just like to get more information on that, particularly in terms of the extent that fair use is applied. And then I'll ask a third question. Just bear with me. So the one thing I am quite concerned about was with regards to the technological amendments. There was a suggestion to include wording around AI, and the department saw fit not to include that. And I noted the comment that this could be included in later discussions. AI is already here. it's already causing a lot of issues in terms of people's general sense of security, in terms of their copyright. It's a very advanced tool. Its uptake is faster than anything else we've seen technologically. And I think if we don't use this as an opportunity to legislate, by the time we look at this bill again, the repercussions will be unimaginable. And if we also consider that the last time this bill was properly amended, it was in the 1970s. It would be a missed opportunity not to legislate on this now. So I would like to get a bit more feedback in terms of the decision not to regulate or not to make those amendments in terms of AI, given how significant of an impact it is having. So I will put those questions to you now, DDG, if that's in order.
Thank you, Chair. Okay, I'll start with the legislative process. There is a legislative process that is government process that outlines the steps that must be followed in terms of procedures to approve a legislation. And that process touches on the CSS, the socioeconomic impact assessment systems. I think that's where the research comes in terms of how the legislation of regulatory impact assessment studies or research. That part is forms part of the policy, what is evidence-based policy making, and it's something that is not applied in a standard way. So, for instance, there are one can maybe look at how different legislation came about. The CSS are they are legislative requirements. Of course, they started in 2015. They changed the system to that, to be specific about the CSS. I think what one can say is that research is important, Chair. Making sure that when policy is made, there are proper proposals that are informed is very important. And that also talks to issues of consultation. So going hand in hand with your research and consultations. So yes, there was a research in 2014. The Copyright Review Commission came about in 2010. That we had 2010, I think, until 2012 or so, we had that. So it was part of that process as well. And there were other studies that we have dating as far back as I think 2009, 2010, and so on, and throughout. However, on the regulatory impact assessment, I do note that many stakeholders have raised it as a major concern to say there should have been one on fair use, there should have been one on different provisions. So that is noted. But if you look at the timelines of when things occurred, we had this in 2014, and then we had the draft bill in 2015. We were introduced in Parliament in 2017. So those things happened before. They happened before the actual introduction to Parliament. So there was that effort to ensure some level of evidence-based making. And I'm not saying this to undermine what everyone has been saying, that we haven't done a thorough job around these things, but there was that consideration of some kind of evidence-based mechanism, some kind of studies, research, some review assessment. So there was that. We think the timelines were aligned in terms of when things happened, because we were working on these things, and the draft bill was also informed by all these coordinated processes. Then the CSS came as well from the presidency. I think as far back as 2016-17, as I have indicated, they did those CSS, and yes, that combination then informed some of the initial draft of the bill of what was there. So it was not arbitrary, and there was work that also happened in Parliament. There was work that was done. There was some drafting that was done in Parliament with certain academics and experts. So the bill took on more. There were many changes that happened with the bill. It had a lot of processes that affected how it ended up looking. There was the departmental part, then there was a parliamentary part, where there was part of drafting, part of reviewing some of the provisions in Parliament. So we note that until this point, there has been lots of changes and updates on the versions of the bill, but we think that a process was followed. So then after the CSS and the bill drafted, and then processes in the clusters and processes in cabinet, then is introduced in Parliament, then it becomes a parliamentary process. Then that's when everything starts unfolding, depending on how Parliament approaches it. In this case, it was initially a Section 75 legislation that did not have a provincial element, the way we have it now, where we are consulting with the provinces. It was retagged in the National Assembly. Hence, we have these processes now consulting with provinces. So I would say that we followed the legislative process the way that we had to. And yes, there were concerns from the public about the role they could have played and how they were supposed to be involved in the different regulatory impact assessments and privy to policymaking in government. So there's always observations and lessons that can be learned in some of these processes. But I think that we did follow the legislative process the way it was supposed to have unfolded. And that impact assessment was meant to help to ensure that some of the issues are highlighted for us and to make sure at least we have something, not just a thumb-sucked approach to the issues. So on the artificial intelligence point and the recommendation from the department, I think you are right, Che. We are living in a very digital world. There's so much that is affecting, whether it's cybercrime, whether it's corruption online, cross-border issues related to trading online and so on. There's so many issues around the importance of technology, and we agree with that. The reason why we recommended that this issue not be incorporated now, we noted with the, let me use an example of the fair use provision. There are many stakeholders who are even today of the view that there was not sufficient consultation on fair use. We are very cautious to just incorporate new sets of amendments that have not been researched. You are also questioning the validity of our process in terms of research, that we didn't do enough research. As valid as artificial intelligence is as an issue, to just take it as is and put it in the bill, it's going to have ripple effects. Ripple effects, there will be groups who say, we were not consulted. There was no regulatory impact assessment studied on artificial intelligence, and it might be found unconstitutional on the virtue of public participation. So while we note its importance and its significance, we also note that procedurally it might have other challenges. So that's why we are cautious about that. But I have noted your concern that it's something that can make a difference in the context of the current era we find ourselves in, with changes in digital innovations and risks that are involved when it comes to the cyber environment. I hope I've responded to the different, the models of fair use. Which countries did we look at? So when the portfolio committee decided on the hybrid model of fair use, the first model we looked at was the draft bill, I think the Singapore model, where it had a list of exceptions. It had a list of exceptions, and fair use was a proposed provision. I think they were also discussing the four factors at the time. The factors in the Singapore model. And then we looked at other countries such as the US and Israel as examples of where fair use is applied. And what was very for us inspirational about the US, I mean, everyone knows about the thriving US copyright-based industries. The creative industry there is thriving. Yes, there might be issues of jurisprudence, the fact that the legislation also provides for the damages and so on, but no one can debate how effective part of innovation, part of development in their side of the creative market has been enhanced from an innovation point of view, from research information by the use of fair use. And it has been noted by many experts around the world. So these are some of the examples we looked at. Thanks, Chair.
Thank you very much. I do note a comment in the chat function. If I can please ask members of the public, Please do not use this as a platform to incite a position necessarily. If you feel that there is something that should be brought to the attention of the committee, you're welcome to use the chat function. But let's just have a bit of courtesy towards other members who are on the call as well, and who are here to listen to the deliberations of the department. Members, are there any further questions? I see no further questions. I do have just a last round of questions. It's on the two bills mentioned. The current presentation by the department responding to the various submissions, it's noted that on a few occasions, that some submissions would be submitted or considered by the select committee. So the question really is, does this mean that you foresee another engagement with the select committee? And just on that, where does this leave us in having or considering the negotiating mandate, in terms of particularly the timelines and the process going forward? And also, if you could just share with us an overview on what it means for the current status in other provinces, especially if we look at how tight these timelines are. Hope that makes sense. Thank you.
Thank you, Chair. The reason why, okay, in April we presented, there were public submissions we had to consider for the select committee in the NCOP, and there were certain recommendations we made to them. The reason why we brought them here as well is just to show that we've noted some of the common issues, and we've already highlighted the recommendations to the committee, the select committee. So this process, I must say, with the bills that we've worked on before that had provincial Section 76 implications, departments are not normally called like this to platforms like this of this nature. Hence, the Western Cape is the only province that has done so in this process. We normally go to the select committee, and then the provinces will bring their mandates to us. They bring their mandates to the committee, to the NCOP, and then the NCOP will then deliberate on the mandates. The department's role normally ends with the select committee when we deal with the public in that format. So this one, for our side, it's a new process. But then because of the emphasis of ensuring that we serve government, we then participating. Usually it would have ended with that process with the committee. So the areas where we said we've recommended to them is because we have also, they were raised, and some of them are common. Hence we brought them. We just wanted you to know that we also agree with the stakeholders that we think some of the areas should be reviewed, and we are considering, we gave those recommendations to them to say we are considering it. So that report that was flagged when the meeting started is part of that process. We went to that process, then there was a report that was then finalized a week later. So in terms of the processes in the province, it's difficult for us as the department to say, because we don't normally get involved to this extent. So usually there will be those mandates submitted to Parliament, and the department will be requested to come in there to support that process. So in terms of other provinces, what I can share is that we have not presented to any other parliament in this format. And then the second thing is that in the other provinces, we've been going for the public hearings. We've been in the hearings, ensuring that we are in the different platforms where hearings do take place. So one cannot speak to the next step in terms of the negotiating mandates, because that's the parameter of the province. But we can, where needed, to come in and clarify what we have done or areas of concern, we can avail ourselves to support the processes. Thanks, Chair.
Thank you very much. With that, I also want to congratulate the committee on being the first committee to have done the deliberation on the bill. Thank you very much, DDG. We really appreciate the questions and the answers and the very, very detailed feedback you gave us. Members, are there any final questions? I see no questions. With that, DDG, we just want to thank you again for your time. It's been incredibly helpful and insightful to put it all together, and we've learned a lot throughout this process. It's been a very long process. So with that, we would like to excuse you. And then members, I would like to propose that we again have another, let's call it a 5-minute breather. Actually, no, we have 15 minutes left. So I think for the sake of time, we should continue, but we'll excuse DDG, and then from there, we'll move on to our resolutions.
Thank you, Chair and honorable members. Thank you. Bye.
Thank you. All right, members. So we will now move on to the next portion. With that, I would like to remind you that the committee will meet on the 11th of May to deliberate on and consider and adopt the negotiating mandates for CAB and Performance Protection Bill. I also want to remind you that at that time you may express your views on the bill and prepare for the negotiating mandates. Also that there are 2 bills, so this means that there will be a negotiating mandate for each of the bills, and that means that there are 2 separate final mandates as well. Then from there, once the discussion on the mandates concludes, I can indicate to you that the committee will adopt the resolutions, recommendations, requests for further information, and once those resolutions have concluded, we will have wrapped up with this very, very long process. So members, if I just want to get an indication from you, are there any further questions or issues you'd like to flag? I see none. Just from my side, perhaps as a note or a resolution from today, that the department, as they committed to earlier, to share the CS report and the Farlam report so that we can also share that with industry who've contacted us on the concern of no social impact assessment having been concluded, if that's in order with members. Okay. Everybody's very quiet.
Thank you. Fine
It's
with me.
okay. It's okay, Chair.
Thank you. All right, members, thank you so much. That concludes today's standing committee, and I wish you a great weekend going forward. Meeting adjourned.
Thank you very much.
Thank you, Chair.
Thank you, Chair.
Thanks.
Thank you very much. Thank you very much. Have a lovely weekend.